relevance speculation.
So I think I will sustain the objection if we can move on.
You know that the author of the article that Free Speech Systems was relying on was anonymous, correct?
For this article, yes.
And you know that the videos that Mr. Schroyer showed in this of the medical examiner, Dr. Wayne Carver, was cut off at the end, correct?
Yes.
And it was cut off for the purpose of lying to the audience about whether or not parents were allowed to come into contact with their children, correct?
Speculating about the contents of another mind or the purpose of.
Overruled.
I can't testify as to the reason why it was cut off.
Okay, so Free Speech Systems here today to testify about this video that showed a video of Dr. Carver cut off, cannot tell this jury why it was cut off.
Same objection, Judge, speculation.
I don't know why because I can't
Excuse me.
say.
That was a yes or no question.
And my answer is I don't know.
The answer is you can't tell this jury why it was cut off, correct?
That's correct, yes.
He also showed a video at the end of another couple, correct? A couple that lost their child at Sandy Hook.
Yes.
That video was cut off before it ended, correct?
It was cut off, yes.
Why was it cut off?
Same answer, I don't know.
Free Speech Systems doesn't know.
Correct.
Objection.
It knows that it cut it off.
Just, there's an
May
objection.
I have standing objection to the form of any question, Free Speech Systems. She's here as a legal representative.
I don't think
She's
we need a
not the
speaking
corporation.
objection, Your Honor.
I'm just asking for a standing objection.
Very well.
Ms. Paz, do you know that the medical examiner's statement, if it had been allowed to continue, would have confirmed that after the children were identified, the parents were allowed to see their children? Do you know that?
Yes, I know that there is a longer piece of that interview.
And that that's what it shows.
Yes.
But Free Speech Systems chose to cut the video off there, correct?
It was cut off, yes.
And Owen Schroyer said, I guess we're not going to hear any explanation from Mr. Hessler on this, right? Do you recall that?
I don't know if he said it like that, but he said maybe we have clarification from Mr. Heslin and or Megan Kelly. I think that's what he said.
And Free Speech Systems chose to run this video to retaliate against Mr. Heslin for having cooperated in the Megan Kelly piece,
Same
correct?
objection, standing.
I can't testify as to why he ran it. I know Owen was deposed on
Excuse
this
me,
issue.
ma'am, so you don't know?
If your question was if it was retaliatory, no, I can't say whether it was retaliatory.
You met with Alex Jones, correct?
I did.
You met with Owen Schroyer, correct?
I don't think I was able to speak to Owen while I was there. I don't recall speaking with Owen. I read his deposition.
How many on-air hosts does Free Speech Systems have?
We have Mr. Knight, we have Mr. Dew, we have Mr. Schroyer, we have Mr. Jackson at one point.
David Knight was fired 2 years ago, wasn't he?
Right, I mean during the
I'm
time.
asking right now.
Honestly, I'm not sure right now, but he doesn't work there now, Mr.
No.
Knight.
So how many on-air hosts does Free Speech Systems have right now?
Objection, relevance, Judge, what's it have to do with the complaint?
Overruled.
3 or 4?
Is that a guess?
I'm not sure, 3 or 4.
So Free Speech Systems coming here to testify can't tell this jury how many on-air hosts it has,
Same
correct?
objection as to the form.
Overruled.
3 or 4.
Okay, who are they?
Mr. Dew, obviously Alex, Owen's still there, and maybe one other.
Ms. Paz, Mr. Dew no longer works for Free Speech Systems, does he?
I don't think he works there currently, but
So he's
he
not
was.
an on-air host, is he?
Excuse me, Judge, objection, she's not finished.
I think she was finished.
I think
don't.
she was finished too.
I
So
wasn't
this-
finished.
Okay, well, we'll move on to the next
Okay.
question, but I think what you're doing is not answering
Oh, okay, I'm sorry, I'm trying to answer his question.
We'll ask the next question.
When I was there and I interviewed.
There's no question pending
Sure.
right now, okay? I just want to please understand whether you can tell this jury how many on-air hosts InfoWars has. You started out by saying 3 or 4, then you said, I'm not sure, then you went back to 3 or 4. I asked you to name them. You said Alex, you said Rob Dew. You agree with me, Rob Dew is not employed by Free Speech Systems right now? Yes or no?
Yes.
Okay, so Rob Dew is not an on-air host, right?
Objection, that's argumentative that he made.
Overruled.
Right?
Presently,
Yes.
no.
Okay. So you got Alex, you got O, right?
Right.
Who else?
I'm not sure, people come and go a lot, so I'm honestly not sure as I'd hear.
So the only on-air hosts that you're sure about are Owen Schroyer and Alex Jones, correct?
Those are the ones I'm sure about, yes.
Okay. And you knew that you were going to be asked about this video with Owen Schroyer, correct?
Yes.
There are only 2 on-air hosts that you know of, right?
Presently, yes.
And you decided not to speak to one, right?
It's not that I didn't decide not to speak to him, it just wasn't available to happen for whatever reason. I can't recall.
You testified on the first day here, man, that you have an independent duty. When you're coming here to testify under oath before this jury, to find out what you need to find out, to speak on behalf of the company, correct?
Yes.
You were given Owen Schroyer's phone number, weren't you?
Yes, I believe I had his phone number.
Did you call him?
I did not call him, no.
Okay. Your call broadcast on October 26, 2017. Why don't we bring up the chart for Ms. Paz, please?
What was the date?
October 26th.
Okay, yes, I see it.
Okay. It's another video in which Mr. Jones talks about Sandy Hook, right?
Can I have it back up? I'm sorry. The title is JFK assassination documents to drop tonight, full show, but I do believe he's mentioned Sandy Hook in that
Right.
broadcast.
Let's play clip 40. Actually, Your Honor, we offer 43A, please. That's not yet in evidence.
It's a full exhibit.
Oh, it's been reason. Gotta get better at that. Sorry, Attorney Farrell. Let's play
That's why
43A,
we have
please.
Mr. Ferraro here.
Gerald Salente is going to be hosting the 3rd hour today, and then we're going to have Nancy Cooney in the 4th hour. I was thinking, you know what? Just let him have the hour. I want to be here, but I'll just interrupt the whole time, so he'll be here. I'm going to get to some of your calls, and then come up in a few minutes. We'll get breakdown for Salente on what he's going to be covering in the next hour. Top trends forecaster. But look at this article that was on Infowars.com a few days ago that I read, I meant to cover, and then I heard Leanne McAdoo during the break. A lot of our radio ads aren't radio ads, they're just 1 minute little information news pieces. It's something we do, we just change things up. And I'd forgotten in the documents, the CIA visited Lanza and reportedly recruited him about a year before the shooting. I mean, they bulldozed the house to get rid of it. I don't know what really happened with Sandy Hook, folks. We've looked at all sides. We played devil's advocate from both sides. But I mean, it's as phony as a $3 bill with the CNN doing fake newscasts, blue screens. And I mean, Nancy Grace got caught doing it, Anderson Cooper. I mean, that is just a crazy, that's the kind of stuff that I read on Infowars.com that I don't even get to.
Phony is a $3 bill. We've heard that before, right?
He's said that quite a few times.
And the records that he referenced that the CIA had went to Adam Lanza's house. What records are you talking about there?
Objection, it's speculation, contents of another mind.
I don't know, he doesn't say.
He doesn't say there, but he must have said to you when you interviewed him, right?
He did not say that when I interviewed him, no.
And that was October of 2017, yes?
Yes, I think that's the date.
Nearly 5 years after the shooting, he's still going at it, isn't he?
This is almost 5 years later, yes.
Now, Ms. Paz, you can take that down. Thank you. You know that the plaintiffs demanded that InfoWars produce videos that it broadcast concerning Sandy Hook, correct?
Right,
And it produced some, yes?
right.
There were a number of videos that the plaintiffs had to find on their own, correct?
I believe that's right.
Including a whole number of videos that InfoWars did produce to us, correct?
I'm sure that's accurate, yes.
And as we've gone over before, InfoWars has no idea how many videos and articles it published concerning Mr. Jones' lies about Sandy Hook, correct?
Do I know whether there is a specific number? Is that the question?
No?
Okay.
But the question was, you testified earlier that InfoWars has no idea how many videos or articles it published about Mr. Jones' lies about Sandy Hook. You testified to that, correct?
Right.
Thank you. But one of the things that Free Speech Systems maintains are radio logs, correct?
You mean like show logs? The logs of the shows?
Radio logs. That's what they were produced us as radio logs. You know that?
Okay, yes.
And radio logs are basically outlines of the show, yes?
Right, it's kind of like minutes for the show, what is spoken about at what time. It makes it easier to find things later.
Doesn't really give you the substance, but it gives you the topics.
Correct.
And InfoWars doesn't have radio logs for all the years, but it had some, yes?
Right. I don't think they had started making those until later, so they didn't always make those.
Why don't we pull up Exhibit 50, and let me just confirm with Attorney Ferraro that that's already in.
50 is in full
It
exhibit.
is.
And you know, have you seen this before?
I have not seen a summary chart.
Okay.
No.
I'll represent to you that this has been admitted as a chart of all Sandy Hook related broadcasts as described in radio logs for which there are no videos. Okay?
Okay.
So all of the videos that we've seen about Sandy Hook, they're not on this.
Okay.
Right? This is a summary chart just for radio logs showing that Sandy Hook was talked about, for which no videos have been produced. Okay?
Okay.
And let's go to the first page. The first date there, what do you see, Ms. Paz?
April 8th, 2013.
Let's just kind of scroll through. What's the last date there?
October 4th, 2021.
It's about 8 years?
After Sandy Hook, is that the question?
No. These broadcasts about Sandy Hook cover about 8 years, do they not?
From 2013 to 2021.
Okay. And if the jury wanted to see any of these videos, they can't, because InfoWars didn't produce them, correct?
Well, I can't say whether we have them or not, but they were not produced. Whether we have them is different, but
Well, if you have them, they should have been produced, right?
I can't say that we have them. But they have not been produced, correct?
Exhibit 2016, please. 216, I'm sorry.
That is a full exhibit.
Agreed.
You'll recall, Ms. Paz, that we've looked at this exhibit before. This is the media kit for 2014, right?
Yes, I remember.
And this is the one with the language that neither one of us could understand.
Yes,
Let's
I
go
remember.
down. I think so.
Right.
But
I
there is a
remember.
part here that I did want to look at here. You see kings of their domains down
Yes.
here, right? And then I want to look at that topping the charts section here. All right. Now, we looked at this a little bit before.
Yep.
And the point of this media kit is to show potential advertisers just how dominant InfoWars is in the marketplace, correct?
Right, this is why you should want to advertise here.
Right, because InfoWars and PrisonPlanet.com are significantly bigger and more popular than the other websites listed, correct?
Right.
And the third website listed is glennbeck.com, right?
Judge Aston answered, we did this yesterday.
That's what it says.
And Glenn Beck is also a media personality, right?
I believe so, yes.
Quite conservative, correct?
I don't know a lot about him, but I believe he is a conservative commentator,
Okay.
similar to Rush Limbaugh.
Similar to Rush Limbaugh, correct?
Correct.
Rush Limbaugh at one time was a very popular and widely listened to radio host, correct?
Right. I don't know if he's still on the air. He might still be on the air, but
Also very conservative, yes.
sure.
Both men considered fairly controversial and provocative, yes.
I mean, I don't know a lot about them, as I said, so
Okay. And as far as Free Speech Systems knows, neither one of them said a word about Sandy Hook, correct?
Objection to the form.
I don't know the answer to that. I don't know if they've ever spoken about Sandy Hook. I don't know.
Okay, so as you sit here right now, Free Speech Systems has no basis to say whether or not they've ever said a word about Sandy Hook, correct?
No, I don't know anything about their shows.
What about Newsmax? You understand Newsmax via Newsmax.com is a website, and Newsmax itself is a kind of news company, fair to say?
Yes.
A news company that's considered fairly conservative.
Yes.
Do you have any idea whether Newsmax has ever said anything about Sandy Hook?
I don't know. I don't know anything about Newsmax.
Can get out of that. Now let's go to, I want to go back to Dan Bandi.
Okay.
All right. Now Dan Bandi is the gentleman who was chasing down and harassing the lawyer for the town of Newtown and the chief of police for the town of Newtown yesterday, right? You saw that video?
Yes.
This is the gentleman who the jury heard was described laughingly by Mr. Jones as the Kraken, correct?
Correct.
When we send Dan Bandi on a mission, we say release the Kraken.
He has said that, yes.
And after Mr. Bandi sent that footage into InfoWars, they had him on for an interview, correct?
Oh, yes, they did.
They had
Correct.
him on to talk about what he had done on the sidewalk there,
They did,
right?
yes.
All right. One moment, Your Honor. You've reviewed a video in the past called Fight for Freedom of Information at Sandy Hook.
Yes, I believe so.
And this is an interview that Rob Dew, then employed by InfoWars, did with Dan Bandi about his coverage of the FOIA hearing.
Yes.
This is going to be 478, Your Honor.
That is not a full exhibit, Your Honor.
Is it late edition? May I speak to Attorney Mann again?
Certainly.
They would approach it.
This video that disclosed Attorney Harris.
recess so you can watch it?
No.
I'm happy to recess and then watch it.
It's a long video. Okay. I don't want to do that. There are two blank spots on the exhibit list, 4, 7, 3, and 4 that I heard 2 and 3. And now this, and I'm worried about what anything else. This is it for videos. Okay, I'll withdraw the objection.
Can you put it on his screen for him to see it? Do you need to see
No,
it?
I don't need it. I know what it is. I just was more concerned about the tip of the iceberg.
Got ya. All right, so no objection?
Correct.
All right, full exhibit?
Before we do that, Ms. Potts, you remember when I was showing you the Glenn Beck and the Rush Limbaugh and the Newsmax, right?
Yep.
They never said that Sandy Hook was a hoax, did they?
I'm sorry?
They never said Sandy Hook was a hoax.
I don't know if they did or didn't. I don't know anything about them.
They never said it was fake.
I don't know.
They never said it was synthetic.
I don't know.
They never said nobody died there, did they?
I don't know.
They never called these families actors, did they?
I don't know.
Why don't we pull up, this is July 8th, 2015, we're gonna play that clip. We have a clip?
After the second hearing, you actually tried to question Chief Kehoe. He, I guess, recently resigned, like maybe announced it the day before. What was your impression of his body language and how he wanted really nothing to do with you? He seemed to be afraid of you at that point.
Yeah, I mean, from the first hearing to the second hearing, I mean, he was just quick answers. He looked like he didn't want to be there, wanted to get the hell out of there. And of course, a resignation comes in the night before the hearing. And that's the first question I hit him with, is about him resigning. Why you resigning? Then of course I followed him all the way out and I tried to get answers out of him. Of course, no dice. The state police actually grabbed him to put him in the state police car to escort him to his car. And then we went after Marty Frank after that, the lawyer.
Yeah, the lawyer seems to have a vested interest in keeping whatever the narrative they want to push going. He's now, running with charities. He rides his bike for these charities. He founded one of them, Team 26 for Newtown. How has he been? Did you try to interact with him at all during these hearings?
Yeah, so when I went after Marty Frank, I mean, I was just asking him the questions, just regular questions. He did not want to answer, so he's looking at my press credentials, trying to figure out who I am. And I told him, hey, we're here to expose corruption. And this guy fits the bill of somebody out of Central Casting. And he's a perfect person. He looks like Mr. Burns or somebody from The Simpsons or whatever, running a nuclear power plant. But I mean, this guy is somebody out of Central Casting. I mean, this guy is a joke. Representing corruption.
Yeah, and he seems to have more of an interest in stalling the proceedings and objecting and trying to make sure, Halbig's got every I crossed and T, T crossed and I dotted.
So they had Mr. Bandi back on, right?
Yes.
They'd obviously seen the footage, they aired it, correct?
Yes, they were airing pieces of those footage.
They had him on to call the town lawyer, somebody who's
Who's they?
Free Speech Systems, the company you represent, had him on to call the lawyer for the town of Newtown, somebody representing corruption, correct?
That's what he says.
Somebody out of Central Casting, correct?
That's what he said.
Just another actor, right?
I believe that's what he said.
Now, when InfoWars was sued, Alex Jones got very nervous about its relationship with Dan Bandi, didn't he?
Objection to the form?
I don't know.
Now, you never read Alex Jones's depositions that he gave in Connecticut, did you?
Right, I think we went over this yesterday.
But you did read a deposition that he gave in Texas, correct?
I did.
And you read Alex Jones's false testimony that the last thing Dan Bandi ever did for InfoWars was cover the Boston Marathon bombing in April of 2013,
Objection
correct?
to the form, argumentative, assumes the fact not in evidence.
Did he testify that Dan Bandi didn't work with InfoWars after the Boston bombing?
Let me ask you my question again.
Okay.
Mr. Jones testified falsely that the last thing Dan Bandi ever did for InfoWars was cover the Boston Marathon bombing,
Same
correct?
objection, Judge.
I don't recall the testimony. If you'd like to show it to me, I'd be happy to look at it.
Let me see if I can get you to recall just the basic fact. You do know that Alex Jones testified in Texas.
Yes,
You know that he testified about Dan Bandi.
I do.
You know that he testified about the timing of when Dan Bandi was last associated with InfoWars,
I
correct?
believe he did, yes.
And you know that he said that the last time that Dan Bandi was associated with InfoWars was the Boston Marathon bombing, correct?
I don't recall.
Okay, so that's the one thing you don't recall
I just
about.
don't recall the specific testimony. I apologize.
We'll bring that up for you a little bit later.
Sure.
You know, though, that that's not true, correct?
That he worked for InfoWars after the Boston bombing?
Right.
Oh, right. Well, this is after the Boston bombing.
He
Correct.
worked for InfoWars into 2016, correct?
I'm not sure the exact date that they severed the connection, but he was a contractor after that. So yes,
You don't know when the last time he actually did anything for InfoWars was?
I can't recall the exact date.
You
No,
know it was 2016, though?
so that's somewhere thereabouts. Yes.
Right, because he was thrown out of a political rally, and finally they decided not to use him anymore, right?
Yes, there was an issue, and he was asked to return all the gear and stuff.
But after Alex Jones was deposed in Texas, you're aware that Dan Bandi went on a podcast and said that Alex Jones had lied about what he did for InfoWars, correct?
If he went on his own podcast,
He went on a podcast
okay.
and said that Alex Jones had lied about his relationship with Dan Bandi, right?
I have not heard any of Mr. Badandi's podcasts.
And but you know that as Free Speech Systems corporate representative, don't you?
Objection, form, foundation, corporations don't know things, Judge.
Your Honor, the speaking objection should stop it.
Based on your investigation.
I have not.
Overruled.
I have not reviewed any of his podcasts, so I don't
No, you
know
haven't
that.
reviewed his podcast, but you've spoken to people at InfoWars who know that Dan Bandi went on a podcast and said that Alex Jones had lied about their relationship.
I don't think I had any conversations with anybody about Mr. Badandi's podcasts.
And that after Alex Jones became aware that Dan Bandi was concerned, Alex Jones called him, correct?
Foundation, objection.
Overruled.
I don't know.
Have you reviewed Mr. Badandi's deposition?
I don't know. I don't recall reviewing his deposition.
You don't recall if you did?
I don't recall. Sorry.
Are you aware that Alex Jones called Dan Bandi in the presence of a lawyer to speak with him?
I am not aware of that, no.
Are you aware that Alex Jones apologized to Dan Bandi and invited him down to Texas for dinner
No,
and put him on the phone with a lawyer?
no,
Do you know who that lawyer was?
no.
Are you aware that when Dan Bandi received his subpoena, he sent some text messages to Rob Dew?
Did Mr. Badani text Mr. Dew?
Yes.
I'm not aware of text messages. I haven't seen them.
Are you aware that Rob Dew texted him back?
No,
So you haven't seen those text messages?
no,
You know what happened to him?
no.
But one can understand why Alex Jones wouldn't want this jury to know that Dan Bandi was associated with him, right?
Argumentative, speculative.
Let's go to exhibit 182. You remember Steve Pichenik?
Yes.
Steve Pichenik is the gentleman that Alex Jones invited on in the spring of 2013, so a few months after Sandy Hook, to say that the parents were crisis actors and the children were actors, yes?
That's what he said on the video, yes.
Okay. And before we pull it up, I just want to make sure it's full exhibit.
It is a full exhibit.
Agreed.
Okay. Exhibit 182 has been admitted as a text message, Ms. Paz, between Alex Jones and his producer, Nico Acosta. And I want you to look at this first part here. This is a text message from Alex to Nico. Bullets flew for 4 minutes as armed deputy waited outside. It's a link, right?
Yes, that's what it looks like.
Okay. This is, by the way, February 23rd, 2018, right?
That's what it says on the
5
text.
years after Steve Pichenik was on the show, claiming that the parents and the children were actors, yes?
5 years after Mr. Pichenik was on, yes.
Okay. And who's coming on, according to Nico, on February 20, just the blue ones, please. That's fine. Who's coming on, according to Nico, on February 23rd at 2018?
It says Syrian girl at noon, doctor, DR period, I assume means doctor. Pichenik at 1 p.m. and Doug Hagman doing 4th hour.
Okay. And so in 2018, Alex Jones was still having Steve Pichenik on the show, right?
That's what it looks like. He was on before that too.
Had you ever seen this text message before I just showed it to you?
No,
Have you looked at any of Alex Jones' text messages?
I have not seen any of Alex's text messages.
Why not?
I don't know.
Did you ask for them?
I don't think I specifically asked for text messages, no.
What did you specifically ask for other than his deposition and your deposition?
I asked for all of the depositions. I did ask for access to all of the Connecticut discovery. I know that there was an issue getting access to the Connecticut discovery,
Okay.
but I did ask for it.
Okay, let's go one by one. You asked for a copy of all depositions, right?
Right.
Okay. You just testified you don't know if you read Dan Bandi's, right?
Yeah, I don't know. I'm not
Do you
sure.
know whether it was given to you?
I don't recall.
Okay, so
It might have been amongst the Texas material, so I did have access to a Dropbox of
I'll
Texas.
represent to you that Dan
Okay.
Bandi wasn't.
Okay, so then it may not have been in that material. I don't recall.
Okay. So as you sit here right now, you asked for the Dan Bandi deposition, but you have no idea whether you received it.
Well, I asked for all of the depositions, so that would necessarily include that.
And you said you asked for all the Connecticut discovery material. That means the material that InfoWars produced to our plaintiffs here in Connecticut, correct?
Correct.
And when you were deposed by me earlier this spring, you couldn't say whether you'd reviewed any of it, correct?
The Connecticut discovery?
Right.
Right, correct. There was an issue with getting me access to the Connecticut discovery.
Okay. But the fact of the matter is, when you showed up for your deposition, you couldn't say that you'd reviewed any of the discovery that had been produced in Connecticut, correct?
Correct.
Okay. So we saw Pichenik, Bandi. Let's pull up Exhibit 191, please. This is already in evidence. You remember I was asking you yesterday?
That's not actually.
Oh.
91 as an exhibit.
I don't object.
I thought we offered it yesterday. Just let me check 1 second. I want to make sure
Do
I'm
not
not
object.
right thing. Sorry, I had the wrong one. It's my mistake. 204. This should be in evidence.
204 is a full exhibit.
Agreed on 204.
All right. Now, you remember I was asking you yesterday when Rob Dew had most recently communicated with Wolfgang Halbig, right?
Yes, I remember we talked about this.
All right. So if we go down here, this is November 17th, 2020, right?
That's what it says from
Okay.
Rob at his personal email.
This is 2 years ago. Rob using his personal email. You know Rob Dew was an InfoWars employee at this time, correct?
At that time, yes.
Yes. Can you read it, please?
Hey Wolfgang, great talking with you today. Please don't mention anything about the federal court move. We do not many to tip anyone off inaccurate phrasing there. Also, please send me the 3 names from your depot list and any including information. Thanks, Rob.
Right. You think you probably meant to say, we do not want to tip anyone off.
We do not, right, he probably said many instead of want.
Now you've never reviewed this email, I take it.
I've never seen this, right?
Okay. But you do know that there was a point while this lawsuit was pending where InfoWars tried to remove the case to federal court. Do you know that?
Yes.
Okay. And it was right around this time, wasn't it?
I'm not sure the time period.
And what Mr. Halbig, I'm sorry, what Rob do, Mr. Jones, one of Mr. Jones' top employees is doing is sharing information about this lawsuit that he doesn't want Wolfgang to share with anybody else, correct?
He's saying, please don't mention anything about federal court. So it sounds like they had talked about federal court.
Right.
In whatever conversation he's referencing.
Right. And then he's asking him to send him the 3 names from Halbig's depot list, right?
Right. That might have been referencing the list of people that Mr. Halbig wanted to depose.
And this is 2 years into this case, correct?
Right. This case was filed in 2018.
Okay. When did Mr. Dew next talk to Mr. Halbig?
I don't know. I haven't seen this email, so I don't know if there's any after this.
Well, let's go up and see. So Wolfgang responds, right?
That's what it looks like, yes.
Okay. So let's just chart this out real nice. Let's go down to the bottom. Great talking with you today, right? So there's a phone call, yes?
It doesn't say how they spoke, it just says that they spoke.
Might have been FaceTime, might have been Skype, right?
Might have been text, it might have been email, it might have been,
Well,
I don't know.
he said great talking to you, didn't he?
I don't know what that means. It could mean a lot of things, so it just means to me that they communicated, I don't know how.
Okay. But anyway, follows up with an email, and then Wolfgang emails him back, right?
That's what it looks like the next day.
And he's giving him suggestions for who InfoWars, the company you represent, should depose in this case, isn't he?
Seems to be in response to his request to say, send me your list of people you want to depose. So these are the people that Mr. Halbig would like to depose.
And he says, have Alex demand under the CT Freedom of Information public record request a copy of the Connecticut State Trooper 1 helicopter radio transmission. You see that?
I do see that, yes.
Did Alex do that? Do you know?
I'm unaware of any FOI requests that Alex has filed.
Okay. Let's go to exhibit, before we pull it up. I don't believe this is yet in evidence. Why don't we pull it up just for Ms. Paz, please?
Number, please.
198. Ms. Paz, you testified yesterday that Paul Watson was the editor of the InfoWars website back in 2013, correct?
Yes, I believe that's what he did at that time.
Okay. And he's still associated with InfoWars, is he not?
Yes.
And the text message that you see here is a text message that Paul Watson sent to Alex Jones in April of 2020, correct?
No objection to its admission in full, Judge.
Yes, April 2020, that's what it says.
Have you seen this text message before?
No.
I'll offer it, Your Honor.
No objection, so ordered.
That was 198, Your Honor.
Thank you.
Let's pull up just the first, there you go. So this is a text message from Paul Watson in April 6, 2020. He sends Alex Jones a screenshot of an article on Infowars.com, right?
That's what it looks like.
Right.
It's hard to see.
And the headline says, a little bit's cut off, but see if you'll accept this. This is how it looks to you. Staged. Video shows hospital using dummies in ER for coronavirus footage. Right?
That's what it looks like. It is a little bit cut off, but that's what it looks like.
Okay. And obviously in April, COVID had just hit within the last couple of months, right?
Right.
Right. And what Alex Jones was telling his audience was, number one, the globalists had released COVID upon them to kill them, yes?
Are you asking me about the coronavirus footage or
I'm asking
COVID?
you about generally the claim that Infowars put out that coronavirus was intentionally released by the United States government to kill people.
I haven't reviewed anything related to COVID coverage, so I mean, I'm generally aware that he covered the COVID-19 pandemic.
Did I just describe what he said accurately or no? Or you don't know?
I just don't know because I haven't reviewed the COVID coverage.
That's fine. In any event, Paul Watson sends Alex Jones this text message, and what does it say?
This is a video of a medical student training to intubate, makes us look ridiculous, suggesting this means COVID is fake, Sandy Hook all over again.
Go down to Mr. Jones's response. What does he say?
He responds, I get it, and then he posts a few hours later a video on banned video, or he texts him a link to a banned video.
Actually, I don't think it's a few hours later. If you look, maybe it's the next day, isn't it?
Oh yes, you're right. I'm sorry, it is the next day.
This is a video of a medical student training to intubate. Makes us look ridiculous, suggesting this means COVID is fake. Sandy Hook all over again, and Mr. Jones says, I get it, right?
That's what it says.
Do you know that that article that Mr. Jones said he understood it was ridiculous remained on Infowars' website for 2 years?
I don't know anything about that article.
It's a good time for our break, Your Honor.
I think so. All right, so we'll take our 15-minute morning recess. Ron will collect your notebooks. You will, of course, continue to obey the rules of juror conduct, and we will be back in session at 11:45 promptly. All right, have a nice break.
All right.
made my colleagues aware of this. And these proceedings are being televised, and apparently Wolfgang Holbig is watching these, and he has left an unusual message that on my client, on my representative's phone. And I know he's been flooding the court with complaints of feeling that he's being defamed in these proceedings.
Attorney Pettis, when you say the court, I'm not aware of anything personally.
The clerk has forwarded material, I don't mean to suggest that you,
Yeah.
I don't know, that has forwarded material. We have no contact with Mr. Holbig. Ms. Paz is not gonna return the call. If I may speak to Holbig through these proceedings, knock it off, okay? But I wanna make everybody aware of it because I don't know where this is going. They've become increasingly urgent, his communications in the last few days.
Have you received any communications that you mentioned? Attorney
You
Pettis?
asking me, Your Honor? I'm sorry?
Yeah,
I think all we have received is what was forwarded to us by Attorney Ferraro.
which I have not seen, because it has not been forwarded to me, and I don't need it forwarded to me, thank you very much. Okay, but so noted. Are we ready for the panel? All right. Welcome back. Hope everybody had a nice break. All right, the record will reflect that the entire panel has returned. Please be seated. Whenever you're ready, Attorney Matty.
Thank you very much, Your Honor. Ms. Paz, welcome back. So we've kind of gone through the videos, we've gone through the summary chart videos of 2021. And really, I think it's fair to say that ever since 2012 and right up until the present day, InfoWars is aggressively trying to build its audience, correct?
You mean over the last 10 years, is that the goal of the business? Sure, yes, that is the goal of free speech, is to grow its viewership, expand, things like that.
And I don't want to retread all of this, but the whole idea here is the more people putting their eyeballs on InfoWars content, whether it be on social media or the website or anywhere else, the more people can get funneled to the store to buy stuff, right?
Yes, that's the business model, essentially.
Let's take a look at Exhibit 183, not yet in evidence, so please just pull it up for Ms. Paz. And please let me know when you have it before you.
Sure. Yes, I see it.
Okay. And you see that this is an email regarding an affiliate one sheet dated April 2nd, 2018. You see that?
Yes.
Okay. and this affiliate one sheet relates to InfoWars audience numbers, yes?
Can I see the whole email, please? Thank you. Okay, yes, the radio audience numbers through the radio affiliates, yes.
And there's some other numbers on there as well, right?
There's some-
Page views.
There's some YouTube information, as well as some other things, yes.
Oh, offer it, Your Honor.
Can I see the top of it, please? No objection, Judge.
All right, full exhibit.
All right, so, yeah. So this is an email between several InfoWars employees on April 2nd, 2018, correct?
That's what it looks like, yes.
Okay, and who's Scott Bronson?
No, I'm not sure. I didn't speak to Mr. Bronson.
Okay. You don't know what position he has?
I'm not sure, no.
What about Mr. Castaneda? Do you know what position he has?
Same, no,
John Hanson?
no.
Okay. Let's pull up the body of the email. And here we go, yeah. So it says, Robert, here's the information we want to put on the affiliate one sheet we spoke about on Friday. Any questions, feel free to ask John or myself. And the affiliate one sheet is kind of the audience numbers Alex Jones sends to new radio stations to get them to carry his show, right?
Yes, so
Okay.
it's a one-page information about the show to provide to other stations.
Right. And right now, I think he's got more than 200 affiliates around the country, right?
Right, I'm not sure the exact number, but it's something to that
It's about
effect.
that?
About, yes.
Okay. And if we go down to item number 2, market reach and stats, there it is, the 200 plus AM, FM stations, right?
That's what it says, yes.
6 million daily listeners, yes?
That's what it says, yes.
Okay, and with respect to YouTube, 2.3 million subscribers,
Yes,
1.5 billion views, yes?
yes,
And it says Alex is the #1 guest on the Joe Rogan podcast of all time with over 5.5 million views, yes?
that's what it says, yes.
Okay. And did you recall that when Bill Aldenberg testified, he testified that one of the reasons Alex Jones is so powerful is because he has these platforms. Do you recall
Foundation
that?
Judge, she wasn't in the room, she's testifying.
No, she wasn't. She watched clips, I think, Judge.
I'm not sure whether I watched that clip or not.
You don't recall?
I don't
Okay.
recall, yeah.
All right.
Sorry.
That's okay. And then it goes from radio to YouTube to Infowars.com, and here it's providing some of those data points we saw from Google Analytics yesterday, right? 11.2 million visits.
Yes, I see that.
Okay. 3.5 million uniques. Yes.
3.4 million, yes.
Thank you. I'm sorry.
That's okay.
25.7 million views, and this is all in the last 30 days from when this email was sent.
That's what it says, yes.
Okay.
Yes.
Then there's some audience demographics breakdown here.
That's what it looks like.
They break it down along gender lines, age lines, educational level, racial lines, and income, correct?
Yes.
Okay. And then you go down further. And Mr. Jones also, and I don't think we've mentioned this before, can be reached through satellite TV, right?
That's what it says on here, yes.
Well, and you know that to be the case, right?
I think it's on some channels there, yes.
Okay. And we go down to radio. Streaming audio and video. This is where he's talking about his podcasts, right?
That's where he would have talked about podcasts, yes.
Right. So like the Alex Jones Show, the War Room. Another way you could get it was because they would just take the show, turn it into a podcast, load it up on, wherever you get your podcast, as they say.
Sure, right.
Okay. We can get out of that here. All right. Thank you. Now I want to take you forward to, I believe, we wanted to do 189 next. oh no, I'm sorry, 190. Not yet in evidence. Why don't we just pull it up for Ms. Paz's screen?
I see it.
See that? And this is.
No objection, Judge.
I'll offer it. No objection.
Ordered.
All right. This is an email from a gentleman named Tom Pappert. Yes?
Yes,
He's an InfoWars employee.
yes.
What does he do for them?
I'm not sure what his title is.
Okay. Do you know like what his responsibilities are, even though you don't know his title?
He was involved with the marketing, but as far as what he did for that, I'm not sure.
And you're getting that just from having read
Correct.
his sign off there, his signature,
Correct.
right? Okay. And he's sending this out to Lisa at everydaymedia.com. Yes?
That's what it says, yes.
All right. So my name is Tom Pappert, and I work with InfoWars. I was referred by Dan Clayton Luce at Henry USA. We would be a great fit for Henry, and I'm interested to see if we could find a way to start a relationship. What's Henry USA?
Henry is a gun manufacturer.
Okay. So would it be fair to say then that what they're looking to do is to have Henry USA start advertising its products with InfoWars?
That's what it sounds like from this email.
Okay. And as a way to kind of induce that, he says the Alex Jones has 6 million daily radio listeners, about 900,000 online TV viewers, not including our over-the-air and cable affiliates, and receives about 45 to 50 million visitors per month.
That's what it says,
Right?
yes. Mm-hmm.
Okay. And then he attaches a rate card and demographics. And this was in November of 2019, wasn't it?
That's what the date says, yes.
All right. And why don't we pull up exhibit number 41? I believe this is in as full, but I just asked.
It is a full exhibit.
All right, so why don't we pull up exhibit 471?
Oh, I'm sorry. I thought you said 41.
Oh, hold on.
471?
Yes, sir.
That is not a full exhibit.
All right, I think this is agreed to as there being no objection.
I don't remember what it is. It wasn't on your reading list. Thank you, sir. No objection, Judge.
All right, now this is an email from Gabriella Tolentino, InfoWars employee, yes?
Yes, I see it.
And she's sending this directly to Alex Jones, correct?
Yes, that's what it looks like.
AJ76 at alexjones.net, correct?
Yes.
Okay, and you know that that's the email address that he uses?
I know that's his email address.
Okay. And let's start to scroll through this. It says attached an updated version for IW, that's InfoWars social media, correct?
Yes.
And as it stands today, Ms. Paz, InfoWars has a vast network of social media platforms it's on, correct?
It's on many platforms, yes.
So let's go to page 2. Cover page there, InfoWars Social Media Reconnaissance Report, February 2021, right?
I see it, yes.
Okay, and if we go to the last sentence there of that paragraph, the following report details the results of current social media recon of InfoWars and Alex Jones 2021, right?
That's what it says.
All right, so let's just start scrolling through here. So here we have, these are all the different social media platforms that he's on, right?
Yes.
Okay, and all of the content that Free Speech Systems pushes out, just as we've been discussing during the time frame that we were previously focusing on, goes to all these social media platforms, right?
Right, so I don't know when we would have set up these particular platforms, so, you know, I don't know if it was around the same time period, so whenever the videos with Sandy Hook started, but generally speaking, if we had the platforms, all of our content gets uploaded to all of the platforms.
Right, and the
Correct.
idea there is you just want to reach as many people as possible.
Correct.
So it's Minds, Gab, MeWe, let's just keep scrolling through here. Telegram, Parler, VK, Subscribestar. We'll just scroll down so people can see. I'm not going to make you count these all up, Ms. Paz, okay? PolitiChatter, Trump Book, MAGA Book. Let's keep going. Let's keep going. Oh, hold on here. So these now we're seeing some live stream platforms, right?
Yes.
Twitch, Vimeo, DLive, Trovo, etc.
Right.
And this is in addition to him streaming live to his own website, band.video,
Correct.
and Infowars.com, yes?
Correct.
Okay, we keep going down. Text message alerts. Okay, so this is another way that Alex Jones reaches his audience. He'll send people who have given him his phone number text messages, right?
Right. If they sign up to receive the messages, then there's a program that he can automatically send the text messages to the subscribers.
Similar to his daily email newsletter, yes,
Right.
that we talked about earlier.
Right.
How many people have signed up to be contacted by text by Alex Jones?
Sorry, I don't know the number.
Okay, let's keep going down. Here's his podcasts, right? You can pick them up wherever
Right,
they
that's
list
where it's
there.
available.
Okay, got it.
Right.
And then just all the links if you want to click, right?
Right.
Okay. And all of this audience growth has led to ever greater financial success for Alex Jones, correct?
Yes, I mean, during this time period, the sales have increased. So yes.
And one of the ways that Alex Jones keeps track of, you can take that down, keeps track of just how well the sales have increased is by getting daily sales reports from Mr. Fruget in the past, correct?
Right, he gets them daily, maybe not daily, but almost every day.
He wants to see it every day.
He does.
And so when Tim Fruget, just remind everybody, Mr. Jones is a longtime business director, was business director, he'd be sending him daily sales reports every day, right?
Right.
And he'd have sales over InfoWarsStore.com, yes?
Right.
And like how many units were moving, meaning top selling supplements for that day.
Right.
Okay. So why don't we pull up Exhibit 195 and we'll go to page 25. I don't believe I think these are already in.
195 is a full exhibit.
Right. I'll represent to you, ma'am, that these are text messages between Tim Fruget and Alex Jones. And what I want to do is just pull up, if we could, pull up just the bottom there with the date. There we go. All right. So we see here on January 27th, 2020, Tim Fruget is sending Alex Jones a text message at 7:49 p.m. and he says, "We are at 205,000 right now." You understand that to be for the day, right?
Correct.
And just on InfoWarsStore.com, right?
He doesn't say where the numbers are from, but so I don't know by looking at this text message.
Okay. And it says the newsletter is performing great right now, right?
Yes.
And what
Yes, it
that means is they've sent out an email earlier in the day in which people could click on it and come to the store, and he's saying that email is really generating a lot of revenue for us.
Right.
Okay. And he says, hopefully it will continue through the evening, right?
That's what it says, yes.
Okay. And then he tells them 110,000 gross sales in food equates to almost 70,000 in pure profit, right?
That's what it says.
And 2020 got better for Mr. Jones as it went on, correct?
How do you mean?
I mean, those daily sales really started going up, didn't they?
Oh, I don't recall. I would have to look at the numbers.
All right, well, why don't we do that? Why don't we go to page 32? Tim Fruget, again, giving his daily reports here. Jury may remember this from opening, where in late February, Alex Jones reaches out at 7:02 a.m. in the morning on February 26th, right? See that?
Okay, yes, I see it. Just wondering how money, dollar, where.
Yeah, and right before that he had said, I know it's early.
Okay.
Right? But 7 a.m., he's reaching out, he wants to know what's going on,
That's
right?
what it says, yes.
And Tim Fruget says, we ended up about 810,000 yesterday, right?
That's what it says.
Gonna take me a bit to calculate what percentage of that was food. Obviously, percentage of food is important because we saw that profit margin, right?
I don't know if that's the reason why it's important, or they were just trying to monitor whether it's something they wanted to continue, increase sale of, just monitor how it's doing.
Exactly,
Right.
Because Alex Jones decides, what sales he's gonna run, right?
Correct,
What's working, right?
correct,
He thinks about what he wants to talk about to figure out, what's gonna sell well, yes?
correct.
And he goes, gonna take me a bit to calculate what percentage of that was food, but it's looking like 650 to 700,000 in food sales. We are already over 100K today at 6:45 this morning. Crazy, right?
I see it, yes.
Alex Jones gives thumbs up.
He gives a praying emoji and a thumbs up, and then a ghost emoji.
What's the ghost mean?
It's just a ghost with a tongue sticking out
And
his
an
tongue.
eye patch.
I don't know if that's an eye patch, but it's just, I don't know.
Just having fun.
It's a cute emoji.
And this actually, this kind of rate of revenue has continued to increase even since 2020, correct?
Objection, fact not in evidence.
I think that the daily sales fluctuate a lot. So if you want to look at annual sales, I think that's a little bit more helpful, but sales in general have increased. But daily sales will fluctuate.
Right. And just recently, is it fair to say that InfoWars is doing just about $1 million a week in revenue?
Oh, I'm sorry, I can't recall the exact number of revenue. You mean presently?
Yeah, presently.
I don't know the number, I'm sorry.
You don't?
No.
Okay. You're not aware whether Free Speech Systems has made any representations that it's doing about $1 million a week?
I don't know if I'm allowed to make reference to the other proceedings.
Well, no, I'm not asking you about
Okay.
any other proceedings. I'm asking you whether you're aware that Free Speech Systems has represented that it's doing about $1 million in revenue a week.
I don't know what the dollar figure is. I know that there are representations that are being made as far as the income that the company makes, and
But
that's
you're not
being
prepared to tell this jury what it is?
what the number is, right?
Does it sound about right?
I don't know what the number is.
Okay. And I think a lot of what you said is that, Free Speech Systems, Alex Jones decides, what's gonna make him some money, and covers topics in order to make that happen, right?
Objection, compound.
I would draw it. What did you just said? Alex Jones talks about things in the news that he thinks is going to drive revenue, yes?
He talks about things in the news that he finds interesting,
Ma'am, I'm going to ask you just to answer the question.
Objection, she's answering.
She's not answering the question that was asked. Do you need it played back?
No, I don't. Is that the sole reason why he says things that he says? No, but is that a reason? Sure.
Ms. Paz? You know what question I asked you.
Objection,
I-
badgering.
So,
Is he saying
Ma'am,
things for
I think the judge
revenue?
wants to have a word.
don't speak when I'm speaking.
Sure.
Do you need the question played back? You need to answer the question that was asked, not the question you want to answer. Would you like the question read back? I can have that done because you made several efforts and you're not answering the question that was asked.
If Attorney Maddie could just repeat it.
No, it's not what I said. Do you have the question or do you want the court reporter to play it back?
I believe, can I ask what the question was? If it was,
I'll
did
have
he
the
do
mon-
it?
We'll have the question played back.
Sure.
Yes, hold on one second. Take your time.
You know what, Your Honor? I think I can do it a little bit faster, because I think we've covered this. Okay. Ms. Paz,
Just wait till we get back on the record.
I'll withdraw that.
Thank you.
Do you remember, I think it was Tuesday, I forget which day it was, maybe Wednesday. We talked about how Alex Jones covers things like increased radiation in the news so he can sell iodine. Remember we talked about that?
Sure.
Okay. He talks about food shortages being inflicted on the world so he can sell storable food, right?
Compound, Judge?
Overruled.
Does he talk about food shortages and then plug an ad for food? Yes.
He talks about chemical pollutants being used to decrease human libido and depopulate the world, and so he can sell super male and super female
Object to
vitality.
compound,
Correct?
argumentative.
Overruled.
Yes.
And he's been talking about this trial this week because he thinks that's going to make him money, correct?
I don't think that that's the reason, but
You've been watching the show this week?
have I been watching the show?
Yeah.
No, I don't generally watch the show.
Okay, so generally though, what Mr. Jones does is he's trying to attract audience so that he can send them to the store, right?
That's the business model we've been talking about. Yes.
And the way he's been attracting audience this week, while we all have been here, is by talking about this trial, correct?
Objection, facts not in evidence, she doesn't know.
Sustained.
Okay, well, let me show counsel exhibit 479. May I approach, Your Honor?
You may.
See that? Do
I do.
you see Mr. Jones' logo for band.video in the corner?
I do.
Do you see Bill Aldenberg depicted in that picture?
I do.
Do you see lettering placed in the lower left-hand corner of the screen that says Alex Jones, Kangaroo Court, watch day 1?
I see that. Yes.
Here's an inch copy.
Sorry, Your Honor. I'd offer it.
It's not self-authenticating. Objection.
Ms. Paz, you recognize this to in fact be a screen grab of footage that Mr. Jones played earlier this week, correct?
She said she hadn't seen it, Judge.
I hadn't.
Overruled.
I've never seen this, and I haven't seen the show, and I haven't reviewed it, so I can't say what this is.
Okay. Mr. Jones and Free Speech Systems, as far as you know, is the only company that controls the band.video platform, correct?
As far as I'm aware,
And you see that logo right on there?
in the upper right-hand corner,
Yes, ma'am.
I see it.
Okay, I'd offer it, Your Honor.
Objection, not self-authenticating.
Sustained.
Move to strike the representations made about what's in it.
Has Alex Jones,
Objection.
I didn't make
Like
the
for
representation, she
ruling,
did.
move to strike the.
Overruled.
Has Alex Jones been calling this trial a kangaroo court this week?
Objection, she just said she hadn't been watching
Well,
Foundation.
she's speaking for Free Speech Systems, and she can have that information without having watched it. I don't know who she's spoken with or what she's done by way of her investigation.
I haven't spoken to anybody this week, so I don't know.
Has InfoWars been calling this trial a kangaroo court?
I don't know.
let me show you 477. Sorry.
This is 477
Yes, sir.
ID.
Right. What do you see there?
Do you want me to describe it?
I do.
I would object to describing a document not an evidence. If
Okay,
you
let me
lay
start this way.
foundation,
Let me
that's
start
a
this way.
different question.
Look at the very bottom of that picture. Do you see any website address there?
I see a website address, yes.
What's the website address?
www.infowars.com/post/watch-highlights-from-the-Alex-Jones-Sandy Hook-court-hearings.
And you recognize that to be a website that's part of the Infowars.com website, correct?
It looks like it's part of that website.
Right. And it depicts Judge Bellis, does it not?
Objection, the document is not an evidence, no foundation to discuss it.
You could ask her what it depicts.
What does it depict?
It looks like that's what it depicts.
Well, you're sitting right next to Judge Bellis.
That's what it looks like.
Okay. That was published on Infowars page according to that URL address, correct?
Objection, it's not self-authenticating, Judge.
Overruled.
I don't know, aside from looking at the URL.
Okay. Well, you're Free Speech Systems, right? You know that that's an Infowars URL, right?
It looks like a URL. I don't know anything about this. haven't asked anybody, and I haven't
No,
talked to anybody about
But
it.
the words on the bottom that you just read,
Right?
if someone were to click on that link, it would take them to Infowars, correct?
I don't know. I haven't clicked on the link.
Yeah. Read does it say www.infowars?
I read it.
Does it say www.infowars.com?
That's what it says.
Okay. You know that's your website address, Free Speech Systems.
That
right?
is the website address,
If
yes.
somebody clicks on it, that's where they're going to go, right?
If they go to Infowars.com, yes.
Okay. And then Infowars.com has a number of sub pages, correct?
Yes.
It's got a videos page, yes.
Yes.
It's got a news page, right?
Yes.
It's got a video page, right?
Yes.
Okay. And if you go to Infowars.com and any other of those sub pages that are listed out further in the URL, it's going to take you to an Infowars.com webpage, correct?
Yes, but if you're asking me, is this there? I don't know because I haven't looked for it.
I'd offer it, Your Honor.
No foundation.
Overruled.
Let's publish this. Is Infowars taking this trial seriously?
I'm sorry, I don't know how to answer that. As free speech, I'm taking it seriously. I've been here for 3 days, so yes.
You're personally, Ms. Paz, you're taking it serious.
No.
Is the
me.
company that you represent, that Alex Jones has 100% ownership and control over, is it taking it seriously?
Objection, foundation.
Overruled.
Free speech is taking it seriously, as I've sat here for 3 days, so
Okay.
yes.
Well, you had to be here, right? They paid you $37,000 to be here, yes? You were under subpoena to be here, weren't you?
I'm under subpoena.
Okay, if you didn't show up here, you would have been in quite a bit of trouble, correct?
Sure.
Okay, so you have to be here, right? I'm asking about Infowars. On a scale of 1 to 10, let's do a scale of 1 to 10. On a scale of 1 to 10, how seriously is Infowars taking this trial?
Objection, Judge, that's meaningless.
Overruled.
I don't know how to answer that.
Well, you got 10 options, 1 through 10.
10, it's serious to me.
Well, Ms. Paz, if it was that serious to you, I think you would have prepared a little bit more, don't you?
I prepared how I was able to prepare.
Right. And I don't think we should blame you for that because, as you said, you asked for everything and you just didn't get it, did you?
I did not get everything that I asked for, that is correct.
And you know the plaintiffs haven't gotten everything they asked for either, right?
I'm aware that there have been issues regarding the discovery, yes.
No further questions, Your Honor.
Attorney Pattis.
that is my role here, yes.
And you were paid a fee to testify.
I was.
Objection leading.
I get to lead. There's case law on that. I'll recite it if necessary. You were paid $30,000 initially.
Yes.
You were initially offered 20 to 25,
Yes, that was based on our conversations, yes.
and then you negotiated yourself a higher rate.
I did, yes.
And you asked that it be supplemented.
I did.
Why?
At the time, what I did was I tried to figure out how much time it would take to review the material and do the depositions. I did do 2 days of Connecticut deposition, and then there were requested, I believe, 2 more days. And then it was going to be clear that I was going to be called to testify here today. And so as much time as I had spent on it, it was clear to me that the retainer needed to be replenished.
You were initially retained to serve as an expert in Texas
The corporate rep in Texas, yes.
because Mr. Jones.
Objection, Your Honor. Yeah, I think maybe should do a sidebar on this.
Yes. She was the, excuse me, did I say expert? You sure did. Then I withdraw that, and I made this, it wasn't intentional, you're looking at me like I'm trying to play a game. I will withdraw it. I will withdraw it, and she was the corporate rep. I'm not getting any. I'm not sure.
You need to.
Okay, I'm just worried about the social media crowd. I disagree because an issue's been made for free, including the last comment about her 37,005. I disagree. You were retained initially just for the corporate rep in Texas, and I apologize to you, and I apologize to you more. Of course I will. And what did you do? What did you do in terms of that preparation? How much time did you spend? Did you appear for a deposition? How much time did that take? In the course of that, did you become There's nothing else. I'm not going to give you a book. If you want to take an early lunch break, and I would reassure everyone fine, but I think I heard the court's ruling, and I think I've been doing this for a few decades. I kind of think I know what I'm doing, but. I'm told I misspoke.
Yes.
You are not an expert in this case.
No, I think in my reply, though, I did say I'm the corporate rep.
Well, my mistake, and I apologize to the court, counsel, and to the jury. When were you first retained to serve as the corporate rep in Texas?
It was sometime in late January of this year.
And did you work with a lawyer by the name of Jacqueline Blott?
Yes.
Was the work that you did in preparation for serving as a corporate rep in Texas related to the Sandy Hook shootings?
Yes.
There was a Sandy Hook litigation in Texas
Yes.
as well. And was there overlap in the work that you did for as corporate rep in Texas and in Connecticut?
There was some additional material that wasn't relevant here that was relevant in Texas, but there was overlap, yes.
When did you first speak? And I don't want you to tell me what anyone told you. All of these questions are going to be your communications or attempts to communicate with others.
Okay.
When did you first speak with Attorney Blott?
It might have been sometime like maybe January 30th, 31st, last week in January, first week in February.
And did you subsequently travel to Texas to prepare to testify as a corporate rep in the Texas case.
I did, yes.
When did you travel to Texas to begin to prepare?
So I had already begun reviewing material prior to that, but the depositions were scheduled, I believe, February 13th and 14th. And then I was there almost the entire week prior.
Between the time that you were first retained and the time you traveled to Texas, how much time did you spend reviewing material?
I spent a lot of time reviewing material. I spent a lot of time watching videos, taking notes on the videos. I did have access, as I said earlier, to the Dropbox material. In the Dropbox material were depositions, there were emails, the company emails. There were a lot of other documents associated with the financials of the company, et cetera. So I spent the weeks prior to traveling down there, reviewing the material in the Dropbox, as well as videos, and then I traveled to do my observations, so to speak.
Can you estimate how many emails you reviewed?
I definitely did not review all the emails. There were many, many thousands of emails. So I was asked this question at my depositions too. I did try to narrow my focus of the email review just to make sure I was reviewing what was relevant.
Objection, Your Honor, non-responsive.
And what topics were you reviewing, were you preparing to testify on?
I was preparing to testify as to the Sandy Hook shooting, so I tried to narrow my focus on Newtown, Sandy Hook, names of plaintiffs, to try to, names of Mr. Halbig, for example, just to narrow my focus on what I thought would be most relevant. There is a lot of spam email in there and such.
And you mentioned that did you review court pleadings and so forth?
Such as the complaints.
Right.
I did read the complaints. I did read some interrogatories, admissions, things like that.
When you went down to Texas to prepare to testify as the corporate rep in the Texas depots, did you go to the InfoWars facility or campus?
Yes, I was there.
Describe.
So when you walk in, it's a little maze-like. You have to have key cards and you walk through doors to get to other doors. It's kind of, there's boxes everywhere. There's papers lying around everywhere. There's really no kind of rhyme or reason to the layout that I could see, but people were kind of spread out. One side of the building was kind of administrative, and then the other side was where the studios were.
Different sides of one building or separate buildings?
I want to say I walked through an area to get to another side, but I wasn't in the studio, so he showed me where the studios were. So it might have been a separate building. I'm not sure.
There was no receptionist there, was there?
Oh, no, there was nobody there to greet you.
There's no phone system in the building where people can call one another, is there?
No, there's not.
And there were somewhere between 60 and 80 employees at that time, correct?
I believe that's correct. That's
And
correct
in
number.
your efforts to determine who did what to whom, did you find out that did they even have a flow chart, an organizational flow chart?
They did not.
How difficult was it for you to get answers about the questions on your mind?
Objection, Your Honor.
Sustained.
Did you make efforts to address, you were asked questions by Attorney Maddie about your duty
Yes,
to inform yourself, correct?
yes,
Did you take that duty seriously?
I did.
Did you have difficulties performing that duty?
I found it to be difficult, yes.
What was difficult about it?
I found it difficult to find out, like if I had a question, to whom I should direct that question, who was responsible for answering that question, if there was a person responsible for answering that question, if that person was there during the time period of this litigation, if information had been conveyed from the old person to the new person. Most people would not know who to talk to. Most of my inquiries were,
Sustained.
okay.
Without an organizational flow chart, how did you make determinations about who to talk to and when?
I would start with a person that I thought should be responsible for such a thing, and then I would ask them, and that person would either tell me whether they were or were not, and try to direct me elsewhere.
Relying on what they said, would you go elsewhere?
I would, yes.
How many times would you go through that process, speak to somebody you thought you'd have an answer, be directed to someone else, in the end not get any information that you were looking for?
It was quite a few times. It was often.
Did you hear the name Mark Enoch while you were there?
I did.
He was a lawyer initially in Texas.
One of.
Then you heard the name T. Wade Jeffries.
Yes.
He was another lawyer.
One of.
There was a guy named Brad Reeves,
Yes.
another lawyer.
Another.
And they'd replaced one another seriatim, correct? One after another.
Yes.
There was another lawyer involved, although not appearing, Jay Woolman,
Yes.
Mark Randazza.
I'm objecting to leading. It's all leading.
I get it.
This is, I don't think that's so.
I'll allow it.
If you need to get the case, I'll get it.
I'm sorry, what was the
And
question?
then ultimately, Ms. Renault was replaced, or excuse me, Ms. Blott was replaced as well, correct?
Yes, she was my primary point person while I was there, but then after I left, she was subsequently replaced.
Were you called upon to testify in a trial in Texas?
No, I'd never testified in Texas.
Did you, in this call simply for a yes or no, did you have any communications with Federico Reynal involving the case at any point?
No, I've never spoken to him.
Now initially, one of the reasons you wanted to supplement the retainer is nobody really talked to you about being the corporate rep in Connecticut when you first appeared in Texas, correct?
That's one of the reasons. I only thought it was for Texas.
When you came into Connecticut, you testified that you were aware of other lawyers involved in the case, correct?
Yes.
Jay Woolman,
Yes.
a fellow named Robert Barnes was at the periphery of it for a while.
Yes.
I got involved,
Yes.
and you and I had worked together.
Yes.
You left and went on to another firm.
I left and went on my own, and then I was at another firm for
And then when
3
that
years.
didn't work out, you went on your own.
Yes.
And I called you and I said, I hear you're looking for work. Correct?
Well, yes, you heard I had left and knew I would be available.
Based on your review of the material that was made available to you, had other InfoWars employees served at as corporate rep in either Texas or Connecticut?
Yes.
Who?
I'm aware that Daria had previously testified as corporate rep. I know that Mr. Dew has. I believe Mr. Zimmerman has on another topic. There may have been another, but there have been
And
others.
as part of your work preparing for this case, did you review the depositions of them that had been broadcast online by Texas Council?
I did.
Objection, Your Honor.
Sustained.
Do you know whether they were willing to serve again? That calls for a yes or no.
I do know.
And what were they willing?
No.
Objection, Your Honor.
Sustained.
Move to strike.
So ordered. Response is stricken, the jury will disregard it.
Have you received harassing emails and texts in the course of your testimony in this case?
Objection, Your Honor.
What does this have anything to do with what the jury decided?
Part of what the reason for the fee is the difficulty of the work and the collateral consequences that come of doing it.
Sustained.
Can Ms. Paz be shown exhibit number 245?
I do not have that as a full exhibit.
That's why I said just Mrs. Paz. I'm sorry, I
Sorry.
could have been more clear. That's a stipulation that the parties entered into?
Oh, I don't see it yet.
Oh, I'm
Sorry.
I don't have a screen here.
I see it, yes.
And it's, you've referred to it any number of times.
Yes.
You've referred to it to refresh your recollection about dates
Yes.
and topics of videos.
Yes.
How many videos are on that list?
Do you want me to count them?
Well, or estimate them. If you can tell Ron when you need to scroll down.
Yes, can we scroll down, please?
Wait, it shouldn't be up as been offered, is it?
No, I said it was possible. I'm sorry.
Can you,
I
can
did
you,
say
Move
this.
the sidebar, please.
You did say that.
I didn't realize he couldn't. It's okay. My guy will do it. Okay, that's fine.
Well, what's the issue?
What? Ron can do it. They control the control switch of who does what. No, excuse me. Mike Curley is here for that purpose. My understanding is that Miss Shishadri controls who has access to it.
She can give it over to him if you want it.
We did this in the past on a prior witness. You know what, Chris? We will wait rather than ask for a courtesy and work this out over the lunch break. And I'm not going to get a personal comment. I'm ready to proceed. I'd offer 245 as a judicial admission. It's a stipulation between the parties.
No objection.
So ordered.
She's gotta forget it, it'll go.
We do need some assistance, Judge, if they'd be so
Yeah,
kind as to flick the switch.
He's got it.
All right, and the stipulation that was just entered as evidence, you can accept it, but you decide what weight to give it. And where are we at now?
245, if that could be displayed, please.
Thank you.
Can we go back to the top of that, please, John? And I said Ron before, I apologize, Ron, I forgot I couldn't do it. Can you read that stipulation, Attorney Paz, in case it's too small for the jury to see?
sure, it's just a stipulation regarding authentication, and this is the list of the videos.
Okay, and what does it mean to stipulate regarding the authentication of something? You're a lawyer?
I am a lawyer, yes. It means that, that Free Speech agrees that these are the videos that were produced by the company at this particular date. These were the titles, and it also lists the unique name. It's a combination of letters and numbers that it was saved under.
Can we go to the second page, please? Third page? Well, let's go back to the second. The Jones defendants do not dispute that all videos produced by the plaintiffs to the Jones defendant as listed and attached in Chart B are true and accurate copies of videos that FSS publicized or otherwise broadcast on or about the dates, correct?
That's what it says, yes.
Can we go down one page, please, John? Not all of these videos, you've not reviewed all of the videos in this courtroom in this trial, correct?
In the courtroom, no.
Could we go down to the next page, please? Same with this list, you've not reviewed all of these in this courtroom in this trial, correct?
Right, we've not spoken about all of these videos in the court, correct?
Next page, please. Next page. Now we're on B. Same question as to this. You've not looked at all of them, correct?
In court, no.
In fact, some of them just say untitled broadcast in the middle of the page.
Right.
11/17/2016. You don't even know what that is, correct?
I don't know.
Next page. And then there's a, you know what? Did you say something?
I didn't see
Oh,
any.
I thought it was okay. Deep State launches martial law through judicial tyranny, 11/16/2021. Do you know what that video was about?
I do not.
You can take that down, John. Now, How many hours do you think you spent watching videos?
I do have records, so I don't want
Can
to
you
miss.
estimate without the record?
Sure, probably about maybe 40 hours just watching videos and taking notes on the videos.
And how many hours did you spend reviewing emails?
I mean, I know how many hours I've spent total in connection with the case. I didn't really break it down that way. I don't want to guess.
Okay. Do you think you overcharged in this case?
No, I don't.
Think you undercharged?
I don't want to say I undercharged, but I don't think I overcharged.
Can we watch exhibit 45, please? This is a video entitled Democrats File Suit to Overturn 2016 Election as Megyn Kelly Reopens Sandy Hook Wounds.
Hold on, one moment, Your Honor.
45 is a full exhibit.
And Ms. Paz, I'm going to show you two exhibits in full. You've seen a lot of clips here, correct?
Yes,
Mr. Jones talks about a lot of things other than Sandy Hook, correct?
he does.
This is clip 45.
I'm sorry, is this a clip or an exhibit?
It's an exhibit, excuse me.
Can we not show this part of it? It's getting me busy.
I don't know how to do that.
I don't either.
Oh, it's off.
I mean, maybe once he gets there, we can put it up, because we're not in a rush, we have plenty of time.
Your Honor, maybe we just approach real quick.
Certainly.
Thank you, I'm sorry.
Chuck, I just want to say one thing before you raise your issue. After we went to Judicial for lunch, before I get off the bench, I'm going to talk to you guys. I want you to think about and tell me what I can do, okay, to make it, I'm going to say easier on you, but just to smooth things over to make it easier on you so that there's not the, so I don't have to deal with the sniping.
It's much better than I usually do.
No, but you know what I mean? Like, what I can do to help you so that we don't have that. Just think about it. I don't need any answer. Just think about it and we'll talk about it before lunch. What I can do to help you. Maybe take some of the caffeine out of the coffee. All right, turn that. Well, this has to be on the record, and so we. No, she can't. Can you hear?
What I understand, I'm kind of confused by a film video, which would exceed the scope of anything I did with this possible perspectives. So I'm objecting as beyond the scope of my acceptance. The video is how long?
About 50 minutes.
50?
You know, here's the problem, Joe Officer.
No, go ahead.
The judge wanted us to do. They have represented three times they've used the following expression, even in their opening statement, that Alex Jones thinks that there is a conspiracy among government.
I'm trying to do it, Jeff. I don't care what was said in the opens. I care about the evidence in the case. So
Okay, in
what
the
people
evidence.
said, and should we do this without a hearing?
No.
I think we should. It's getting close to lunch anyway. It's hard for the monitor to do it. Let's just do
Why
that.
do we have to come up here stereophonically? Who's going to speak for the others? Who's going to speak for the others?
Okay.
I'm gonna let them go to lunch and we'll do it next.
All right, so we have some issues to discuss. So I have made the decision, not everyone agrees with it, to let you go for an early lunch, and we will stay on the record and continue with our issues. So Mr. Ferraro will Safeguard your notepads. I know, I have faith in you that you will continue to obey the rules of juror conduct. We will start promptly at 2 p.m. And I hope everyone has a nice lunch, and I hear the weather's nice, so hopefully at least get a little fresh air and get to enjoy the weather. And if you do that, just be careful, as I say every day, to avoid contact. I see everybody's wearing their handy dandy little stickers there, so hopefully people will know to avoid them as well. So we'll see you at 2. And you can step down. Great. I'll do it. Thank you. Do you want me to leave the program too? Is it necessary for Ms. Paz to leave the courtroom?
She should probably be excused.
All right, that's fine. We'll see you at 2 o'clock. All right, so I think we left off that Attorney Pattis, you were looking to play the 50-minute video exhibit 45. Is that where we
Yes.
left off? Alrighty.
Your Honor, this video was not played at all during Ms. Pattis' direct. It was not played at all. So our first objection is that it is beyond the scope of the direct. Our second objection, though, is
Well,
that
could I just ask for, I have no idea, so it's just for ID, or is it a full
It's a
exhibit?
full exhibit
Okay,
by
and,
agreement.
and, what's it about? I don't know if it's beyond the scope, because I don't even know what it's about. Do I have to watch it first? Because I could do it over lunch.
You may want to, but it relates to Megyn Kelly reopening old Sandy Hook wounds, Democrats filing suit to overturn the 2016 election. I think it is within the scope of the evidence, and I know you don't want to hear about the opening statement that has been offered by the defendants thus far, or
Right,
the
if you
plaintiffs
could
thus
just
far.
keep your comments to
I am.
the actual evidence in the case and
On
not.
2 occasions when, excuse me, I cut you off.
No, that's right, go ahead. I'm
On
listening.
2 occasions when Agent Aldenberg testified, Mr. Maddy went out of his way to use this following locution, and it's almost exact. And Mr. Jones, believes that there are peddles the notion that there is, and this is the quote that's almost exact, and a conspiracy of global elites and business leaders in governments, including people in our government, he said breathlessly, on several occasions. Then there has been testimony about Megyn Kelly, his reaction to Megyn Kelly. They offered a video clip in which Mr. Jones referred to, and I want to find the language, to Chelsea Clinton and another Democrat, I believe, as a sea hag. These items have been sea hags for the New World Order. It was Chelsea Clinton and Megyn Kelly as sea hags for the New World Order. He grouped them together with the Clinton Foundation, and this was in the clip involving his being a precision-guided heavy munition coming in on top of you. I hit the barbed wire, everyone comes in over me. These items have been offered in isolation to the jury to suggest that this represents some sort of modus operandi of Jones to operationalize his people as against Sandy Hook and others. My view is that taken in isolation, they mischaracterize the man and make a caricature of a person who has far more to say than things about Sandy Hook. I am aware of the court's prior rulings with respect to the motions in limine, and would have expected that the party prevailing on them would have trimmed its exhibit list and its presentation of evidence to avoid opening the door to these topics. However, it is my view that they have done so. And to alert the court, there are 2 other exhibits that I'll seek to show just to get all these out at once so we don't have to do them over and over again. I will be offering the Megyn Kelly profile under Exhibit 40, which is not a full exhibit. It's not even, I guess it's not in for identification, but it's on the list. And I won't be offering that for the truth of the matter that Ms. Kelly profiled, but for its impact on free speech systems. Clearly, that's a door that has been opened in the course of the plaintiff's examination. finally, we will offer, and then I do mean finally, Judge, the full 222, oh no, it's not 222. Excuse me. Gotta check my notes. Actually, I'm not gonna offer 222, that's not a video. So that's my offer as to the videos, Judge. I think
So
it is.
you have 45, 45, which is 50 minutes, you said, and then 40.
Which is approximately the same. I won't watch the whole thing, I'll stop it at some point, but I don't, gauge whether the jury still has any interest or not. But I believe that the door has been open to both of those. And to the degree that there may be a timeliness objection, I feel like Gilligan on Gilligan's Island. We just endured almost 3 days of repetitive examination of Ms. Paz. I will be done within 2 hours.
So, can you give me a summary? I mean, I'll hear regarding the objections, but can you summarize in your own words what 45 and 40 are?
Megan Kelly, so Mr. Jones, should he testify, and well, in fact, other exhibits that are in full and haven't been played by the plaintiffs, at least not yet, are Alex reacting to the Megan Kelly interview. And
No, I'm sorry, I just want to make sure I don't lose this. I'm sorry. No, I'm not understanding. So on your cross, you want to play exhibit 45,
right,
which is around 50 minutes, and then you want to play 40 with, then that's the negative. So what I'm just trying to figure out, because I haven't seen them, so I don't know if it's beyond the scope, I don't know anything about these exhibits. So if you could just sort of, in your own words, sort of.
they're classic Alex Jones doing exactly what Mr. Maddie said he did, which is taking on what, there's another reference in another video today to the deep state and to his belief, which is core to who he is.
Right, so can we break it down? So exhibit 45.
Contains all of that. His views of the deep state, his commentary on other things, support for the notion that Mr. Maddie raised, that he believes that there is a global elite comprised of business, financial, and governmental interests, including people in our government, who are out to, as Mr. Maddie put it on 2 occasions in the jury's presence, enslave us and kill us. And that's a little bit of an overstatement. Certainly Mr. Jones believes that we the people are about to be enslaved by globalists. And certainly he believes that globalists want population reduction.
I'm not interested so much in his beliefs as opposed to what these exhibits that you're offering.
They illustrate these points, and I want the jury to see them in their context.
And exhibit 40, which is?
The Megan Kelly interview.
Okay, tell me about that.
So, Mr. Jones, there was some testimony about his reaction to Megan Kelly. They offered a video of his responding to Megan Kelly and Chelsea Clinton, that she has the New World Order. And it is his, and they, I believe, even offered an exhibit and had Attorney Paz read the headline about Megan Kelly I'm not sure they read the headline about reopening the wounds, but Megan Kelly's use of Sandy Hook has come up. Mr. Jones's contention is that this crisis was largely done until it was reawakened by Megan Kelly.
This is his contention, Attorney Pat, is in exhibit 40, because I thought this was the.
This is the Megan Kelly interview, but because it has been referred to as an item not in evidence, I want the jury to see it so they can evaluate the plaintiff's characterizations of it.
And that's where his position that
Right,
you're referring to.
right.
Oh, now I'm understanding. Okay. All right. Attorney Maddie?
Your Honor, the 50-minute, so I think in order to assess the scope, objection, Attorney Pattis' representations that Exhibit 45 is simply a demonstration of Mr. Jones's belief, to me is not sufficient assurance that a 50-minute video is not going to cover things that are prejudicial, that are hearsay, that are totally off topic, that are controversial and provocative, and likely, offered to support the improper arguments of political bias and silencing that Mr. Pattis made in his opening statement.
Right, so let me ask Attorney Pattis about that, because I agree that this is likely to happen. How are we, I thought this was
They're
something.
full exhibits. They marked the exhibit. I agreed to it. How do you say my exhibit is unduly prejudicial? He, eyes wide open, said, "You want this?" I said,
40's a
"Sure."
full exhibit too?
Yes.
40 is
No,
not.
no, 40 is not. 45, but 45 is by agreement to full exhibit.
All right,
But it still needs to be played for a relevant purpose to the appropriate witness. And so what we're seeing here is, I asked Ms. Paz to confirm what Alex Jones's worldview was. She did, she agreed, that's it, okay? I don't think it would be appropriate to put up a video published apparently in 2018 in which Mr. Jones talks about God knows what.
that's how I'm rolling.
Okay, then I would renew my offer, and I'd like to make some supplemental remarks that did not appear to me at the time.
Well,
And that
you
is
mean further argument on something that I ruled on?
in support of what I'm going to be offering.
Okay, well, tell me first what the offer is, so I can.
Our claim is that with respect to Exhibit 222, which is the 2016 set of metrics on page views and whatnot, this was offered midday and mid-morning on the second day of trial, and the claim was that Alex had called that exponential growth. The plaintiffs walked away from that in subsequent examinations and didn't visit 2016, and I think the reason for that is they may have realized that's the year that the Megyn Kelly interview talked about the reasons for that exponential growth, which was Donald Trump. And they have claimed in this very unusual cut book case and made repeated representations, including in the number of, I objected a number of times to compound as to the corporate rep, that Alex sows fear to make money. And that is their cut book claim. There's not a claim about a particular product. May I finish,
No, I
please?
just want, I'm not, it's gonna be lost on me if I don't ask you a question, so. I
It's gonna
don't
get
think-
lost on me if you ask too many.
Well, we'll get back, we can play it back. So exhibit 222 is a full exhibit,
Correct.
and you want to examine Ms. Paz on it?
No, I'm
No.
saying that in terms, it's the predicate for the offer I'm about to make.
Okay,
And to be honest with you, because I try to be, it's also a segue into a motion to ask you to reconsider, because I think that by calling into question the business practices and saying that it's not genuine, that what my client says are lies for the sake of profit, they beg the question of whether he speaks the truth as he sees it and makes money to support that. And that is his defense here as to the cut book claim. Because there is no case in Connecticut that supports what they're attempting to do here, which is to basically stop a man from speaking, as they said, because of the content of his speech under guise of a cut book claim.
but
Now, I
this isn't
understand.
hearing and damages. And I
And our
understand you're
defense-
gonna make a motion at the
No,
appropriate
but
time.
our defense is we concede, well, we don't concede, but we accept for purposes of law of the case your ruling that causation is established. But it's abundantly clear that the plaintiffs have to prove the extent of their damages. And we've briefed that, including our most recent brief this morning. And we believe that arguing exaggeration on behalf of the plaintiffs is consistent with the law of the case. and is as a matter of right, is something that we get to do should they elect to call any plaintiffs as witnesses. Now, they can choose not to do.
When you say they're arguing you're talking about the extent of their damages. Your
Correct.
claim is that they are exaggerating their damages.
For political motives, and that we are entitled, if they testify, to explore that, because motive, interest in the outcome, and bias is never collateral. And so, the accusation in the pleading of the 15th was that I was trying to nullify or otherwise ignore this court's order. I'm not. I'm trying to cross-examine the plaintiffs within the meaning of what cross-examination means, and while accepting for the law of this case the threshold question of damages, we want to put before the jury reasons they may have exaggerated.
Right, but we're talking about Ms. Paz, you were talking about Exhibit 222.
And what I'm saying is they put that in front of the jury. We didn't. And what that exhibit reflects is that the 2016 profits, the 2015 page views, I think, were 4.15 billion individual, I can't remember if it's clicks or not, 42 million engagements, or 29.3 likes. And they did this in the context of looking at the growth from 14, 15, and 16, and then spent days with this jury going through the videos that were about Sandy Hook to support the claim that this was done for the purpose of driving that exponential growth.
So can you tie this up now? So
Yes.
Exhibit 222, this witness.
They then solicited testimony about the interview with Megyn Kelly and Mr. Jones's reaction to it. They have put before this jury the theory that Jones merchandises fear for the sake of making a buck. Our claim is that he recognizes the fear of the people and makes $1 to support that claim. We didn't raise this cut-book claim, they did. And we think that these videos support our defense, and with respect to 45.
So you're back to now the Megyn Kelly video that I already ruled on?
Absolutely. And we'd ask you to reconsider, because we think on the law of this case, I don't want to try the case again. So they've solicited testimony about his reaction to the video. They've called him a liar any number of times. We had a scorecard going in the case before we ruled that the law of the case was that he lied. It was up to 80, 90 times.
So so Ms. Paz testified as to his reaction to the video, yes?
Yes.
And what did she say?
Refer to my notes. Not happy with how the interview was reflected him in Sandy Hook. Then there was a claim that Mr. Jones showed only part of an interview with Mr. Heslin, that somehow that they had manipulated this video to serve their own purposes. And I want the jury to see what was on Megyn Kelly, and I want the jury to draw its own inferences, not argumentative inferences, about whether in fact Mr. Jones misrepresented anything. And I think the Megyn Kelly interview is 17 minutes. The other one I reviewed, by the way, I was wrong about the 50. It's about 19 minutes. These are both squarely within what has been presented by the plaintiffs. And what's more, Judge,
So you're offering like the Megyn Kelly interview to
completeness
to show that he was right to be unhappy?
To show several things. That there was more we didn't introduce the 16 metrics in this case, they did. And here was a widely broadcast interview that was wildly controversial, that is replete with Trump's support of him. And I would say that there were many reasons to be unhappy for the clicks to increase in 2016. And that's one of them. And what's more,
Well, she testified that he was unhappy, and you wanted in to
and that there were misrepresentations about it.
misrepresentations in the video.
Right.
Okay, but the free speech system's her testimony was that he was unhappy.
Judge, look, here's what I got to say about this. I'll make, if the court persists in the ruling, I'll make a motion, which I'm sure will be denied for a mistrial, and here's the reason for it. I've marked as a court exhibit, I think it's 671, an opening statement that I gave I didn't know if I'd be able to give in the course of this case. And it was clear to me that exaggeration and motive was our defense. I didn't know that I'd get to give it, so I printed it out so that if you stopped me, I could mark it for identification. But my view is that the door was opened, and then I was lulled into believing that we were going to be able to try these issues when the plaintiffs who objected to every single exhibit that I offered several hundred exhibits themselves that contain this material. How can this not be? And so any claim that it's hearsay, any claim that it's, that there's some sort of evidentiary foundation has been waived by the offer. What I'm trying to do is defend Alex Jones and his contention. The contention I told the jury, he's an angry populist who, as Mr. Maddie has said to several witnesses, believes there's a global conspiracy to enslave people. It may not be a belief you or I share, but you can't use a CUTPA statute to silence a person for unpopular speech, and that's what they're trying to do here. And I'm pretty confident on my odds in the appellate court, but the odds then will be a retrial. We want to try this case once. That's the reason that we stipulated to withdrawal of the stay in free speech systems in the bankruptcy matter, so that we wouldn't have successive trials. We didn't want Jones to have to go to trial in free speech. We just want this jury right now to decide the issues that the plaintiffs framed. And we think that this material is clearly responsive and within the scope of their case.
All right, Attorney Maddie?
Your Honor, am I arguing on the motion for your motion for reconsideration here? Okay, well, it's okay. Let me say what I think I heard. What I think I heard was Attorney Pattis started talking about 222, which is the 2016 social media metrics. And I think what he was saying was the new reason he's offering the court for why the Megyn Kelly video is relevant is because it suggests that whatever bump in social media traffic may have occurred in 2016 is due to Trump. And if that's the case, it's hearsay. Because if there's some sort of out-of-court statement suggesting that Mr. Jones's new popularity in 2016 was due to Trump, that is hearsay. It cannot come in for that. They're offering an out-of-court video for the truth of that matter. So that's what I heard him arguing on the motion for reconsideration. I didn't hear anything new in the argument about why Mr. Jones's statements, out-of-court statements about Cindy Hook should be admitted now. What we know he said in that video was essentially he was mischaracterizing what he had previously said. Things like, I didn't say that, or I didn't say that. Also hearsay statements that are being offered to this jury to show them Mr. Jones never said these things. Not only is it hearsay, but it also offends the default ruling that the court has made. So nothing I've heard suggests that anything about this video is admissible under the rules of evidence.
But Judge, they waived the hearsay objection by offering. I mean, how do you offer an exhibit and then
Offer the video.
Oh, the Megyn Kelly thing, but I'm
We're talking
referring
about
to
Megyn
245. How do you, how do you offer something and then claim it's hearsay? How does that work?
Your Honor,
For a fair trial.
I'm sorry. I understood 45 was withdrawn so that people could review it to assess.
And I'm reviewing that motion and I'll address it on a seriatim basis, but as to 40, we say rule of completeness, Judge.
All right, so I am gonna deny the motion, and we can get the jury.
Well, we still have the other exhibit, Judge, and if you're not going to permit all as to 45, I
thought I ruled on one before lunch, and I just ruled on the Megyn Kelly one.
I thought you were gonna look at 45 at lunch, that was the shorter one. Did I miss?
I looked at the Megyn Kelly one, I ruled on the other one before lunch. And then there was a third one, but then you didn't pursue it. So
And the
during
basis-
this, and the rulings, during the cross-examination of this, witness. if
So
you-
no part of 40, which has previously been admitted, can be gone over with Attorney
I did,
Paz?
you offered it in its entirety, and there were,
And just for the record, Your Honor, exhibit 40 is not a full exhibit.
45, excuse me.
That's the Megyn Kelly. 45 is the one that is admitted, and you had talked before break, you had said if they wanted to look at it
Right.
over recess and
Sure.
find certain parts, you would.
but I'm not, right, so I, before lunch, sustained the objection on the entirety of the 50-minute video. I haven't changed the ruling, and this is now, of course, we're talking about during your examination of Ms. Paz.
And the basis of the ruling, Judge, just so I understand it for the record, it can't be hearsay because it's in full
Attorney.
exhibit.
I think we're ready for the jury.
My record needs to be complete, Judge. The basis for upholding that objection is?
We're ready for the jury, Attorney.
That's not a legal basis, Judge. May I have a ruling that the appellate court can understand?
There was an objection, and I sustained the
But
objection.
there was no legal basis stated. I'm entitled to that under the practice book, and you should deny the motion on that grounds alone. It's insufficient for somebody to stand up. They're supposed to provide me with notice so that I can respond.
I believe that he argued it for 20 minutes, and I think the
Yes.
record is clear, Attorney Pattis.
He said
and-
hearsay, but it can't
And
be.
if it's not clear, wouldn't be the first time, and you'll move for an articulation, and I'll articulate when I'm directed to by the appellate court.
Your
I
Honor.
understand that there will be an appeal. I assume
Well, maybe
that
not.
there will be.
We might win.
There may be an appeal, there may not be an appeal then, but I assume there will be an appeal.
May I just make one comment, Your Honor?
I suppose so. I just hate to keep this jury waiting because they're so prompt.
Just very quickly, the objection we made to 45 was on scope grounds, among other things, and that's what the purpose of the recess was, to
Right,
review.
and I said 3 times that for the purposes of this witness, during this examination, the objections are sustained. I don't know how many more times I have to say it, right?
No more, Judge. I got it.
I did just want to add, obviously Attorney Pattis is free to use Exhibit 222 with Ms. Paz, but I just wanted to renew my concern about offering any sort of hearsay testimony about why there was a spike in traffic in 2016, which is not based on any personal knowledge she may have.
All right, I think we clarified that on the sidebar. I think that ruling is on the record, and I'm sure that Attorney Pattis is on top of that. I have no doubt. Okay, let's get the judge.
John, can you get rid? Can you get rid?
Oh, yes, please.
Thank you.
And Judge, I'd like to thank the good folks at Koskoff. We had a miscommunication about your order. It was my understanding that the items that we were given would be the exhibits prepared and ready for presentation to the jury. I'm told that the Koskoff firm did not take that to mean that they were going to give me marked exhibits, and therefore my written exhibits aren't marked. So they've provided me with one to use today.
All right, welcome back. Good afternoon, everyone. Good afternoon. Welcome back on this Friday. And council will stipulate that our panel has returned.
Yes, Your Honor.
Yes, Judge.
Please be seated.
I'll over it.
We were dealing with more legal issues before lunch, after lunch, so I know you had to wait for us a little bit. Trust me, we were working hard here trying to make it even more efficient for you, so thank you for your patience.
May I stand over here so I can see the?
Absolutely.
Thank you.
And Judge, are you able?
I'm good, thank you for
May I
asking.
inquire through the court whether it's okay for the jury?
Witness,
I can see it from here, thank you.
whenever you're ready, Attorney Pattis.
Thank you, Judge. John, could you pop up 222, please? And can you go down a page? Another page? Ms. Paz, do you have a screen in front of you there?
I do.
You were asked questions about this on direct examination, correct?
Yes, I remember.
And you talked about the number of impressions for 2016 is 4.1 billion, correct?
Yes.
The number of engagements at 42.9 million,
Yes.
and the number of link clicks at 29 million plus, right?
Correct.
Total fans, and I don't think we ever did get an answer about what the fans were, but presumably that's a good thing. They increased by 57.8%, correct?
That's what it looks like, yes.
And I think you testified in response to a question from Attorney Maddie that Mr. Jones was regarded this as I don't remember the exact point, but he appeared to be pleased by the increase as you understood it.
Sure.
And that represents a substantial increase over 2015, which was and I'm showing you a chart that you were previously shown in the course of your examination, correct?
Yes.
And Mr. Maddie took numbers from a variety of documents and talked about the number of impressions and so forth over this 3-year period, correct?
Yes, I remember.
And we noted a steady increase from 2014 at 2.2 billion to 2015 at 2.9 million to 2016 at 4.1 billion, correct?
Billions, yes.
I earlier showed you Exhibit 245. And can we take another look at that, please, John?
Can you shut it off for a sec, Vertigo?
And this may not bear an exhibit tag, Judge, for reasons I've previously stated. We'll take care of that at the break.
All right, we're good.
Can you please display 245? And this is the list of stipulations regarding videos that were that the parties agreed to in anticipation of trial, correct?
Right.
Did you review all the videos there?
I think we talked about how some of the videos, I didn't even know what they were in
Yeah,
the
titled
list.
ones, right?
Correct. But I think I reviewed all of the ones in Schedule A. If you want to scroll down, I could just tell you for sure. Exhibit A, rather.
And while she does that, Judge, may we approach on a legal issue? I have waited coffee at the lunch break at your suggestion to keep the caffeine down. I'd like permission to ask 2 questions. Did you notice anything, any topics in your review of those that stood out? In other words, Trump and Clinton and so forth, that could be construed as a violation of your order. But I think the record is, did she see these topics reflected in those videos?
I don't understand this story.
You
I
read,
needed coffee.
I need a day off, but we're not going to get it.
No,
She's reviewed the videos. In her review of the videos, did she notice cover? What was 2016? Was it a presidential election? Yes. Did you see coverage that Donald Trump is? How extensive was it? She'll say whatever she was. Did you see coverage of the race against Hillary Clinton? Yes. How extensive was it? She'll say whatever she was. I hadn't prepared this or scripted this. I think on this record, those are fair questions.
So you're going to ask her what the topics were in 2016?
Right.
We have a Roberts objection. It's clear that what the defense was is past this is that there was Hillary Clinton, Donald Trump presidential election, and he's trying to get a backdoor in this.
Well, I think that it's in evidence, right? And she can read off the exhibit what the topics were in 2016 without summarizing the video.
If she's going to ask her to read the title,
No, I get to lead her.
No.
I just want to ask those 2 questions. I think the foundation.
No, I think you can ask her what the
Okay.
topics
Okay.
were. Reading off it, but not summarize.
I'm going to have an objection. What generally were the topics in these videos?
No, that's not the question. right?
Now I'm confused. I thought you just said I can't
You
read
can
on
ask,
something.
she can read off the document evidence.
Okay, but then if she doesn't recall it, do I get to, I have the right to show her because it's in evidence. I'm not trying to game the system, I'm just trying to work the rules to my client's advantage here. And it seems to me that if she says I can't recall, then I get a right to show it to her to refresh her recollection because the rules on refresh recollection are you can do anything you want. You bring a pizza in.
What I hear you saying is, if you show her a videotape and you say, what was that video about? And she says, I don't remember. You can't show a video in the presence of the jury.
Correct. So here's what I would recommend. I claim surprise by this turn of events. I had my opening marked as a court exhibit so the court could evaluate my credibility for itself. I've made the arguments that I have to make. Given the exhibits that were offered as full, I claim surprise here. And I'm going to want to do a supplemental brief on the motion in limine that I filed this morning. I'd like to do that this afternoon and get some rest this weekend because we're going to run into this over and over again.
You're going to end now?
Yeah. I claim surprise
Well, I
because
mean,
I have my adversary objecting to exhibits that he offered. This has never happened to me in 30 years.
That's
But,
not what we're
but
talking about.
that's a different issue.
Mhm.
That's a different issue, and we already addressed that.
I'd like to brief this further.
Well, you
And
can
I've got a
brief it.
request to
You
charge
can
on
brief
Monday
it.
due.
Well, we could move that date, but you could brief it further as we move forward, but I don't want to end this so early, but I'll take further briefs on it. But the issue that he raised was, what, you still have hearsay issues. I mean,
No, I don't. Not. As to an exhibit that's admitted, it's been waived. And so, you have ruled on scope. It's possible that as the law evolves on this question, that she'll say that I don't recall that video, and then I'll show it to her, and then she'll say it. And I think on this foundation, I have the right to put that on.
So what you're proposing to do is ask her about the specific video that the court has already ruled you cannot play without at least examining the scope. And now you're going to ask her what it was about.
Yeah, because the court ruled that the exhibit didn't come in its entirety, and all I care about are 2 words, or 4 words, Donald Trump and Hillary Clinton.
I think we just heard exactly why.
Yeah, of course, I've never just been deceptive. You always act like you're stunned by
Well,
what
I just think it's improper.
I don't think it's improper because we didn't offer those, we didn't agree to those exhibits. They did. And I don't know, I'm entirely prejudiced by this.
Just a reminder, not play this video 100.
the right.
So it was not played.
It doesn't matter. You questioned the business. I'm sorry, you're right, and I apologize to both of you.
I don't feel like when we just got a rule on scope and there was an opportunity to review the video during the break for specific pieces that we thought were responsive to the direct and that didn't happen, that now we should be trying to do it a different way.
You're not going to be done with her anyway today. You can, there's no way you're going to finish.
I would like to adjourn for the day before we brief this because I claim surprise given the way
I'm
it
just trying to figure out what this is. Maybe I just never understood what the surprise was. Don't talk about the opening, because the opening's not it.
I get that. No, I get that.
I don't care about, I just
Judge,
care
I
about
got the
the
memo. I got the memo on that one. But with respect to the case that's been put on, there's been numerous, and I objected throughout her correct, that, on compound basis, that he does this to inspire freedom and make a buck. They're 2 separate questions. They were often put together. The cut of the claim here is that he needs to be stopped because he markets fear for profit. And our claim is no. He profits by appealing to what millions of Americans are afraid about. And it's a different claim. And to use cut by the silent speech will be the subject of a motion of the man if necessary. That's assuming they can get over the ascertainable loss hump, which I don't think they can. I claim surprise because when I wrote that opening statement, I didn't know what they were going to offer. Then they offered it. I thought, wow, I might get permission to make this argument. And everything in the exhibits they wrote told me I had it.
Just briefly in response, I don't think that there's ever any surprise to a scope objection. But secondly, I just want to make this clear since I haven't had a chance to respond. That when in the opening statement, the idea is stop from the line, nothing else. That's what the case is stop from the line, not stop for political reasons, not put out of business. Nobody ever said anything like that. So I just want to be clear.
what I say about the argument, it wasn't evidence, and whatever objections were made, I ruled on, and if people objected, they objected, and if they didn't object, they didn't object. I'm just focusing on what the evidence is.
I'm
This is
clearly
the-
surprised by the attorney defense here.
I don't have a problem though with ending like at 3:30 today.
Okay.
Okay. And then if you want to brief it, talk to each other.
Thank you for your patience.
Can we see 222 again? And can we go down one page? Well, down another page. Okay, here we are. As free speech systems, do you have an explanation for why the page views increased in 2016?
Objection? Hearsay?
Sustained.
Now, you spent how much time on the campus at Free Speech Systems in Austin?
I was there I think I was there from Tuesday through Friday or maybe it was Wednesday through Friday doing interviews. And Saturday, we were also doing interviews for half the day. And then the following Monday and Tuesday were the depositions.
How much time did you spend with Alex Jones?
I met him once at Free Speech. We talked for, I don't know, maybe 45 minutes or an hour or so. I recall speaking to him on the phone. And other than that, I've not spoken to him since.
How long was that personal meeting?
I think it was about 45 minutes, an
And the
hour.
phone?
You have the question?
Oh, I don't have the question, I'm sorry.
Neither do I.
Me neither, but I'll think of one. That time you talked to Alex on the phone, how long did that last?
The phone conversation, well, it was with counsel, so,
I'm only asking, not asking what you
Okay,
talked about. I'm asking
sure,
how long it lasted.
maybe 20 minutes, 30 minutes, if that. It wasn't
So you got
long.
about an hour with him?
Personally, in person, about an hour.
And in person and on the phone, the cumulative amount of time?
Oh, cumulative, maybe a total of an hour and a half total.
Based on your observations of him, in other words, how he responded to you as you spoke to him and what you heard on the phone, did you feel you had his complete and undivided attention?
No, it was difficult to talk to him and get him to focus.
Without saying what he said, why do you reach the conclusion that it was difficult to get him to focus? If you can do it without what he said.
Overruled.
If I would ask him a question, he would kind of go on into whatever he wanted to talk about instead of what the specific question I asked him about was. I would try to redirect him to my specific question, and he would kind of just throw his hands up in the air and continue along the lines of what he was already talking about.
You testified earlier about the business of FSS and what you thought it was involved in. As its corporate representative, how do you describe the business of Free Speech Systems?
Objection, Your Honor, hearsay?
I don't think it is.
No, overruled.
As far as I understand it, the business of Free Speech Systems is to produce the Alex Jones Show and to produce, well, it is essentially a one-man operation in that sense. He is the talent and was the original talent, and so the business is to produce the show.
And you mentioned before there were 60 to 80 employees.
Thereabouts at various different points, it's fluctuating.
Did they have a personnel manager that you could go to find out who had what job?
There wasn't anybody with that specific title, so the answer to that is no. The closest person that I tried to ascertain was a lady named Melinda. However, I believe she's really a bookkeeper. But she operated in that type of function, but there was nobody with that set job description, no.
In the course of your observations there, were you on campus on days they produced the Alex Jones show or other content for distribution?
Yes,
And were you made aware at any point that there were editorial meetings that were convened to decide what would be covered
when I was,
based on your observations?
Yes, and you can answer based on your observations.
okay, did I observe any editorial discussions? I did not know.
And did you find anything in the records that suggested there was an editorial function in the building?
No, I didn't.
You were asked questions, you were asked several questions in direct exam about whether free speech uses Google Analytics. Correct?
Yes, I recall those.
And in spite of being shown a number of exhibits that either bore the words Google Analytics or indicia of having come from them, you persisted in saying that they did not use Google Analytics.
That was the position that was conveyed to me, that's correct, yes.
Did you see anything while you were there that suggested editorial decisions about what to cover were driven by Google Analytics?
That they would use the Google Analytics in order to decide what to
Correct.
write? No.
Do you have any reason to believe that ever occurs down there?
Objection, Your Honor.
Sustained.
Is that why you kept answering they don't use Google Analytics by saying no?
Right.
You were asked questions about various logs and that would record what was displayed when and where. Do you recall that?
I'm sorry, can you repeat that?
You were asked questions about various logs and what was displayed or sent out to the world and when.
Right, yes.
At any point while you were at Free Speech Systems, did you see a record of what was completely produced in 2012 to the present?
No,
Did you see anything at all like that?
no,
Did you meet anyone who had a function that would be to keep those records?
oh, okay,
Yeah,
no.
nobody had a function.
Do
They're all lawyers.
do any of us really? No, I didn't.
You met with Blake Roddy,
I did,
and he was an e-commerce individual.
yes.
And you mentioned that you also spoke, I believe, to Tim Frugier.
Yes, I spoke to Tim on the phone, and I believe I had another conversation with Blake on the phone as well.
But did you ever meet Tim?
I did not meet Tim, no.
Okay, and you mentioned that you traveled to the warehouse,
I did.
and you said the warehouse wasn't far from the studio or the business offices.
No, it was like under 10 minutes.
It was a large building,
Yes,
about the size of maybe 3.5 football fields, correct?
sure, it was big.
And you saw in that they had a series of people, 10 to 12 at any given point, whose job it was to send out mail in response to orders, correct?
Yes, I did.
Alex Jones didn't serve as corporate representative on his own behalf?
No, he didn't.
Do you know why?
Objection, Your Honor. Hearsay.
Sustained.
Do you think Alex Jones would have been a good corporate representative?
Objection, Your Honor.
Sustained.
Do you know whether Alex Jones has ever testified as a corporate representative on his own behalf?
I don't know whether he has.
You were asked some questions about Aidan Salazar and something called crisisactors.org.
Yes, I remember.
What is crisisactors.org based on your investigation? Based on your, yeah, okay. What is it?
From my understanding from just the review of the material is that it provides notifications if there's like some type of listing for actors or crisis actors, if there was need for one.
So if FEMA wanted to do a drill and they needed people to pretend they were injured, they could call them.
Correct.
Based on your observation of the records there and the material that you were able to review, did you see any indication that crisis actors responded to Salazar?
I'm sorry, I don't understand.
Do you see any records that crisis actors responded to Aiden Salazar?
Oh, after he signed up?
Yeah.
No, I didn't see anything like that.
You were asked questions about Dan Bandi appearing at a Freedom of Information Commission in Connecticut, correct? Or Freedom of Information Commission hearing in Connecticut, correct?
Yes.
And you saw videos of that, correct?
Yes.
And you recognize those videos to be the FOIC building at 30 Trinity Street in Hartford, correct?
Yes.
And the Freedom of Information Act is an act that permits the public to request information of a government agency, correct?
Objection, Your Honor.
Sustained.
Did you do any inquiry of Mr. Helbig to find out what he wanted there?
I did not review any of the materials that he submitted. So he submitted his own FOIA request and we didn't have anything to do with his submission. So I didn't review any of the
Did you
material.
ever speak to Wolfgang Helbig?
I have not.
Did you ever try to speak to Mr. Helbig?
I did not know.
This calls for a yes or no. Has Mr. Helbig tried to speak to you?
He has.
Most recently, while you were on the stand this morning, you lit up your phone.
He did call me this morning, yes.
Do you have any reason to believe that Mr. Helbig currently has an association with InfoWars or Alex Jones?
I don't know.
Your Honor, we have a sidebar.
Certainly.
Well, I think that's different than saying that as a result of the default, we can't contest it. You know, Helbig, well, I didn't ask the question. Is he still thinking Sandy Hook's with the code?
Well, the answer is I don't know. What, I think he just says, do you have any current associations? Do they have any current associations? What could I have? And I thought her answer was, I don't know.
I think she said no. I may be wrong, but no, you heard it one way and they heard it, we both
No,
heard it the
I
same way.
thought she said, I don't know. Well, are you moving on? That would be a good
Yeah.
instruction to give in the finance. So you need to go on.
I am moving on. The question I wanted to ask, I can't ask.
So I think that you should put that in your proposed charge.
You were shown a video of the Dondi at the FOIC, and there was a banner on it, truthradioshow.com. Do you know whose banner that was?
I'm not sure.
And John, can you take that down? What's up there? May I have a moment, Judge?
Take your time, please.
Can we see 183 again?
That is a full exhibit, Your Honor.
Thank you.
This was an email that was sent from Scott Bronson, an InfoWars employee, correct?
Yes,
To Robert Castaneda, correct?
yes,
Another InfoWars employee,
yes,
and to John Hanson, another InfoWars employee, correct?
yes.
And what the first line says, Robert, here's the information we want to put on the affiliates one sheet you spoke about yesterday. I think you testified this morning that this was prepared in anticipation of soliciting advertising, correct?
I think what we said was the one sheet was for, to send to other radio affiliates.
All right, and if it says any questions, feel free to ask John or myself, thank you. And it's in 3 boxes of information, network overview, correct?
Right,
For the last 20 plus years, Alex Jones has stood alone voicing the questions of the ignored, the forgotten, and unappreciated, correct?
yes,
Did you reach any conclusions based on your review of the material that you saw down there, whether that's what Alex was doing in his mind?
Objection.
Sustained.
With the help of experts, whistleblowers, and insiders, Alex no longer stands alone. Did I read that right?
yes,
He now has a vast network behind him. Did I read that right?
yes.
With a range of guests like Ted Nugent, who's Ted Nugent?
I'm actually not sure who he is.
Roger Stone,
He's a media personality.
Megadeth frontman David Mustaine,
I don't know who that is.
the director David Lynch,
He's a director.
Blue Velvet.
I'm sorry?
You don't.
I don't know,
Okay.
yeah, sorry.
Mike Judge.
I don't know who that is.
From Charlie Sheen's famous Tiger Blood rant to Donald Trump promising, "I won't let you down, Alex. Your reputation is impeccable."
I see that, yes.
Alex Jones is and InfoWars is firmly rooted in American culture. InfoWars is no longer on the fringe. We are now the leaders in the new wave of media, correct?
Yes,
And can you go to the top of that, John? 2018, that was written, correct?
yes,
And you previously testified about noting the increase in page views from 2014, 15, 16, correct?
yes,
To your knowledge, did an event take place in 2016 involving Donald Trump?
Objection, Your Honor.
Asked the court to take judicial notice that he was elected president in 2016.
And you're objecting on relevance?
Your Honor, I just think that what Attorney Pattis is doing is quite transparent, trying to get around your order.
I don't think so. I think I'm well within the record.
I'm gonna, have the jury step out for a minute or two so we can argue this.
I should leave the courtroom as well, Your Honor.
I think
Yeah,
that's probably.
thank you.
Yeah, that's right.
All right, Attorney, be seated.
Wait, can Attorney Potts get out of the room first, Judge?
Yes, oh,
Sorry.
Your Honor, I noted my concern at the outset, oral argument. I said I remain concerned that Attorney Pattis is going to try and elicit hearsay testimony about the reason for this spike was. You looked at him and you said, he knows my orders. I don't think we're going to have that. And then 3 minutes ago, he asked the precise question we all understood he was prohibited from asking, which was, Ms. Paz, do you have an understanding as to what caused this spike? I stood up, hearsay, you sustained it. He then is going back to it now and has asked her basically by presenting the name Donald Trump in an exhibit, coming back to her and saying, and what happened in 2016, Ms. Paz? So what Attorney Pattis is doing is, first of all, was frontally violating what we all understood he wasn't supposed to do there. And then when you sustained his objection, going back in a circuitous way, pulling up this to try and make the same point to the jury, and it was improper.
There's nothing circuitous about using, the objection was scoped. So I found an exhibit that they used, I found an exhibit that they read to the jury. I then used the demonstrative aid that they showed to the jury. I then showed the jury what they used to create the demonstrative aid I asked her about this. I asked her whether the president was elected in 2016. I got an objection. I'm asking the court to take judicial notice about it. It is for the jury to draw reasonable inferences from the evidence. This is not evidence I produced in violation of a court order. If they were serious about these claims, they wouldn't have offered this. And it's not my responsibility to try their case for them or to anticipate their objections. This is fairly within the evidence that was, this is fairly within the scope of what Attorney Paz was testifying about this morning.
No, it is not. There was no testimony at all, nor has there ever been that we have elicited about the 2016 election. There has not been.
He's not wrong. There is
No, but they're jurors. I mean, he said the jurors are permitted to use their common sense. And the instruction is there are two types of evidence, direct and circumstantial, and you can draw any reasonable inference from circumstantial evidence. If it's too dangerous to tell the jury that a president who they introduced evidence about and has said flattering things about Donald Trump, apparently if it's too prejudicial to have them take judicial notice of civics facts, what are we doing with this jury but treating them like a bunch of imbeciles?
I just don't see how this is
Well, I'll stand by my argument. I think that
entirely.
my view is it's within the scope of the evidence presented, and because the jurors are entitled to use their common sense and draw every reasonable inference, this is not outside the scope. And I would renew my request to have the court take judicial notice of the fact that Donald Trump was elected president in 2016.
So I will sustain the objection. Sure. Ms. Paul's has to come back. Reflect the entire panel has returned. Please be seated. I will give you, thank you for your patience. If I forget to say it, please know that we are very grateful for your patience. And just so that you know, we are planning to let you go at 3:30, so it's just a little bit after 3 now. And we have some motions that we're gonna argue, so we'll stay a little longer, but just around another half hour, okay? Just so you can plan.
Sorry, may I?
Yes.
In your review of InfoWars emails, did it appear that people there were familiar with the normal customs of English language, commas, periods, so forth?
You mean emails from the general public?
No,
no. Okay.
No, the emails, the internal in emails among people at InfoWars.
No, there was a lot of grammatical misspellings, mispunctuation, so no.
in the email that we've been looking at, the rant to Donald Trump promising, quote, "I won't let you down, Alex, your reputation is impeccable," end quote. When you reviewed that, did you attribute any significance to the quotation marks?
I know that what that's referring to. I've seen that statement before, so yes.
Without telling us what you saw before, what significance did you attribute to those quotation marks?
That it was a quote
From
Donald Trump.
May we see 471, please?
That is a full exhibit, Your Honor.
Thank you.
.471?
I can't find 470.
All right, we'll move on. 471 was a video, a recent addition to the exhibit list. Or no, it was an email rather. And it was an email involving a social media report, I believe for 2021. And in that email, there was reference to InfoWars being purged, the purge of Alex Jones. Do you recall seeing that email?
I think so, yes.
Based on what you have read from the records in the InfoWars complex, not what anybody told you, that's what you read and saw, the emails that you reviewed for this trial. Do you have any idea what the purge of Alex Jones refers to? Objection, Your Honor.
Sustained.
Based on your review of the records, did Mr. Jones lose a social media platform in the period 2016, 17, and 18?
Yes.
Did Donald Trump have videos taken down from sites such as YouTube in 2016 and 17, based on what you saw?
Objection, Your Honor.
Sustained.
Now, you weren't asked many questions about InfoWars finances. Were you given access to records involving its finances?
Yes.
And who did you speak to when you wanted to learn about InfoWars finances? I just want their identities at this point.
All of the people I've spoken to?
Yes.
Okay, so initially when I went down to Texas, I spoke to a gentleman named Bob Rowe. And most recently, I've spoken to Mark Schwartz.
Who is Mark Schwartz?
Your Honor, may we sidebar, please?
Certainly.
this is well within the scope of direct. She was asked about this current cash flow, and she said, I'm not sure I can ask, I can answer where, you know, these numbers come from. And, you know, I think they were confused as to was this an
Right, no, but I'm asking, what is, why?
to the degree that they want to argue that, of course, I don't know if they're going to argue it to this jury. They seem to be trying to argue punitive damages in a compensatory damage case. I think the jury's entitled to know that the Alex Jones's company is now rolling in cash, but it's broke. Did she can say who he is? Yes, he did. You don't get to pick the points I make. No, they don't. It's sort of like
So
the notice
what's,
hearsay exception.
just out of curiosity, once, and what are you gonna do, move on?
Yeah, absolutely.
There's no point in that question, there's only one point, and it's an improper one, so sustained.
I don't think so. I think the question was, is attorney Maddox going to finish what Boston did? It seems like no, right? Well, I'll be honest with you, I didn't think briefing in courts at 3:30. No, I don't want to. Okay, the issue is, I'm sorry, yes. If you're stopping at 3:30, we'd like, and you're going to keep going with pause. The request would be to put on witnesses traveling from out of state expecting to go on. If you don't mind going past 3:30.
Why don't you two talk and give me a proposal, but I just told you we're gonna leave it.
Right, exactly. I'm going to be hours of fun. It's based on the concept. Right. Oh, you know, I thought that was at the truck talking about your expert.
I just don't wanna go past 3:30 now. It's 8:30, so you guys talk and give me a proposal, talk and give me a proposal.
I have your back, so we're not gonna go past 3:30. What's the answer, folks? Did you forget?
What's their answer?
I did not hear anything.
Can you tell me what your proposal is?
Continue
Someone-
on with Ms. Potts.
Okay. And we're gonna let our jury go at 3:30 as promised.
Your Honor, I asked for a sidebar before objecting. May I object now to that question, or is Attorney Paddock's going to move on?
I think the court sustained the, I mean, if you didn't, it sure
Well,
looked that way.
I thought it was caught on the sidebar, your objection is sustained.
Thank you. Now, you offered testimony about Tim Fruget.
Yes,
Do you know whether he is a current InfoWars employee?
he's not.
You were asked questions about daily sales reports that Fruget offered, correct, or created, correct?
Yes,
Was there a file somewhere of all those daily sales reports?
no,
And I don't know if I asked this, did they even have a server that everybody had access to in that building?
I didn't see one.
But yet you saw a number of emails that came from the InfoWars server, correct?
I did, yes.
You were asked questions about Henry USA,
I remember, yes.
and Henry USA, you told us, was a gun manufacturer,
I think that's what it is, yes.
and you spoke about a second gun manufacturer that InfoWars solicited business from, and I don't recall its title, do you?
I'm sorry, I don't.
What was their, based on the records that you observed, what was their advertising base? In other words, where were they soliciting ads from?
Objection, Your Honor, time period?
Fair enough, from 2013 to the present. And that's too broad a period. To be meaningful, tell me.
When you say they soliciting, you mean free speech? Is free, okay, I mean, generally, the base which they are soliciting from are conservative listeners and people who are interested in conservative politics, and gun owners would tend to be interested in such a thing.
Your Honor, was that in response to a question about advertisers?
Yeah, I asked about the advertising base.
Oh.
You were shown an exhibit, I think it was 216, which was one of their media kits, and media kits were things that were prepared annually to solicit, presumably ads and so forth.
I believe so, yes.
They referred to themselves as kings of their domain, correct?
Yes, I think in multiple of those, that's how they.
And ranked themselves in association with others, correct?
Yes, I saw that.
Can we do 216, please?
That is a full exhibit, Your Honor.
Thank you.
Well, Hal is not cooperating, Judge. Let me move on without it.
Your Honor, there's a whole bunch of material being displayed that's not in evidence on the screen.
Oh,
right?
sure, can we shut that down? No problem.
Sorry about that. You said you didn't know much about Glenn Beck?
Not really, no.
Do you know that he's a conservative talking head?
I think he is, yes. I've never listened to his show.
Did you know that Rush Limbaugh is dead?
I didn't know that.
Did you know that when he was alive, he was a conservative talking head?
I did know that, yes.
And you were asked about, I can't remember, One American News, and you described that as a conservative outlet, correct?
Objection, Your Honor. There's no question about One American News.
I thought there was.
Newsmax.
Newsmax.
It was
thank you.
Newsmax, yes.
I got him confused. That's a conservative outlet,
Yes.
correct?
Yes.
And here, we got it up. Thank you, Jonathan. WND.com. Do you know what that is?
WND? No.
Okay. But is it fair to say that in this chart, what they were doing is they were situating themselves among other conservative outlets to say to advertisers, hey, look, come to us, we'll get you a bigger bang for your buck.
That's what the intent appears to be.
You were never able to speak to Owen Schroyer?
No, I didn't speak to him, no.
How many times did you try?
I don't think I called him.
Why not?
Time, for the most part.
Is he a defendant in this case?
I think he's a defendant in the Texas cases.
You were shown emails from Paul Watson, in particular an email at 160, that Watson was opposed to the lies at Sandy Hook. 3 years, this is how my adversaries characterized them. 3 years after shooting, there was another email, correct?
I remember those emails, yes.
And you mentioned that Anthony Gacciardi was an employee?
Yes.
In fact, he was a consultant and not a direct employee. Does that refresh your recollection?
I'm not sure if he was an employee or a consultant. I'm sorry, I don't know.
No one at InfoWars had any idea how many times they had uploaded material either in whole or in part regarding Sandy Hook, correct?
Objection.
Sustained.
You were unable to determine, based on your review of the records, how many times InfoWars had downloaded material either in whole or in part to third-party providers like YouTube and so forth, right? You found no records to that effect.
Right.
Did you contact YouTube?
No.
Do you know, as you sit here today, whether YouTube destroyed those records? Do you know?
I don't know. I don't know if they still have them.
May I have just 1 minute, Judge? I'm scanning my notes.
Take your time, please.
Now, you, in your review of the records at InfoWars, did you find a copy of the state's attorney's report, Mr. Sedensky's report?
I believe I saw a copy of it,
And
yes.
Mr. Sedensky, just so the jury knows, he was, at least at that point, the head prosecutor in Danbury.
Yes, he
And
was.
the state of Connecticut is divided into what are known as judicial districts.
Yes,
Steve was the top prosecutor in the judicial district of Danbury.
yes.
And he was asked to compile, and did compile, a lengthy report about what happened at Sandy Hook.
Yes.
And that report appeared how many months after the shooting?
I want to say it was about close to a year later.
Where was that copy of the Sandy Hook report when you saw it?
I recall we saw the email with the link to it. I don't know if the link worked, if it was a link that you would be able to click, or if the report was just amongst the documents. I don't recall which one I saw.
And in your review of the files, well, what's wrong? You've seen videos of Alex sitting at a news desk, correct?
Yes,
And behind him was a screen, a very colorful screen, correct?
yes,
And you've offered testimony that on the table in front of him, there would be a series of printed out news stories?
yes.
Do you know what, did InfoWars have a practice of saving the stories he commented on an individual day?
You mean the papers?
Right.
No, they didn't.
Do you know what, based on your review of, based on your time down there, they just throw them away at the end of the day?
They-
Basis.
Okay. I didn't say that. I said based on.
No. Old.
Basically, yeah, they just threw it away.
Any filing system down there relating to the editorial function?
No, not that I could discern.
Any library videos?
Their library was YouTube.
Anyone tasked with the responsibility of keeping a complete record of what they said, when they said it, and who they sent it to?
No, at some point they made an attempt to,
Objection, Your Honor, hearsay.
Based on the records you reviewed, were you able to determine whether they ever made such an effort?
they made an effort at some point. They started making an effort by making the logs, but aside from those logs, no.
And you went down there looking for that stuff
I did,
with Attorney Blott?
yes.
Nothing further, Judge. There was one other question I had, Judge. I'm sorry, may I?
I think so.
I think at 477, that's an exhibit that was offered today. Can we put that up?
That's full run.
Yes, 477 is full.
Judge, we're going to need assistance on that. That's a late addition. May we ask our colleagues?
What is it that we're being asked to do?
Can you
Display
pull up
477?
477? It's a late addition, if you don't mind.
We have to do that, Your Honor.
Thank you. That's full run
Yes.
today.
We can display it if you'd like, Your Honor.
Please.
Deborah.
I think there was some writing at the top of that when I first saw it. Can
No, Your Honor, it was not admitted with any writing.
Okay. You've not seen this before today?
No,
based on your observations down there, do you believe that Alex has contempt for courts? Not on what he
Objection,
said,
Your Honor.
but on the videos you reviewed, the documents you read. Do you believe he has contempt for the American court system?
Objection.
Sustained.
You believe Mr. Jones believes that there is a crisis of legitimacy in this country?
Objection, Your Honor.
Sustained.
Nothing further.
Your Honor, just for Ms. Paz and counsel, we're going to display 480.
Thank you. I don't think I've seen this one yet.
Ms. Paz, do you see 480 before you?
I do, yes.
Okay, do you see a Bates number at the very top?
Oh, yes, I see this.
Okay. And that Bates number starts with the letters FSS, correct?
Yes,
Stands for Free Speech Systems, right?
yes.
You've seen many, many documents with that prefix and number after, right?
I've reviewed a lot of material that have a Bates stamps that starts FSS and other numbers after.
Right, and when Free Speech Systems produced documents in this case, it identified documents by including a Bates number so that everybody could track what documents were being produced.
Correct, right.
And looking at that document there, that is a organizational chart that Free Speech Systems produced in this case, correct?
Objection, when and when was it created, Judge?
I'm asking the witness. This is Free Speech Systems witness.
I don't know when it was created, but it appears to have a Bates stamp on it.
Right, I'd offer it, Your Honor.
Foundation, when?
You know, Ms. Paz, that this was, because it has a Bates stamp number of Free Speech Systems with the Bates stamp number, that it was produced in this case, correct?
It has a Bates stamp number, so it was produced.
Yeah, okay, go offer it.
Foundation, what period, when?
Look at the bottom tab, Ms. Paz. Do you see that there are several years there with organizational charts for several years?
I see dates at the bottom, yes.
What are the dates you see?
I see 2012, 2014, 2015, 2015, 1, 2 in parentheses, 2016, and 2017.
Okay. I'd offer it, Your Honor, as organizational charts of Free Speech Systems for those years.
Hearsay, Judge, we don't know who created it. We concede it was given up, but was it a consultant? On her testimony, it's not. There's no foundation.
Okay, would you please pull up the exhibit, please, for Tika? Thank you. Ms. Paz, you testified, I think it was in the first 5 minutes of your testimony, you testified that there are no organizational or flow charts at Free Speech Systems, correct?
I've never seen this before.
Right, right. But you didn't testify, I don't know whether there are any flow charts or organizational charts. You testified there are none, correct?
I did not see any.
Right. No, I understand that
Right.
you didn't see any, but if you didn't see any, then it would seem that the accurate testimony would be that you don't know if there are any, right?
Well, I don't know if this was produced in preparation for the litigation, so I don't have anything to suggest that there were, and nothing in my review suggests that there were.
Okay.
So that was my testimony.
Okay, but you acknowledged that you didn't review every document that was in your Dropbox, right?
This was not in my Dropbox,
How do you know?
because all the information that was in my Dropbox had Texas Bates stamps on it.
I see. This is going back to you saying you couldn't even tell whether you reviewed any documents in Connecticut,
That's
right?
correct.
Right, but if it was produced in Connecticut, it was produced by Free Speech Systems lawyers, correct?
One of the lawyers,
Right.
whomever that was.
Right. Well, and Mr. Pattis has been a lawyer for how long?
I'm not sure when he started, but
Okay.
sometime.
Okay, well, he was the lawyer back in 2018, correct?
Objection, it's not true.
As I said, I don't know the dates.
What
that he
about
was retained.
2019?
I'm not sure when he was retained.
Okay, all right. But Mr. Pattis, Free Speech Systems lawyer, stood up here after this document had been produced by his client, and the first question he asked you was whether there were any flow charts or organizational charts, right?
I heard the question.
And you said no, right?
Based on what I had reviewed, I hadn't seen anything
And
like
he didn't
that.
correct you, did he?
I don't think so.
Okay. Well, let's go to 2017. Do we have that up? Is that it? You see that?
The flow chart? Yes, I
Mhm.
see it.
Okay. And who's at the very top of Free Speech Systems?
Alex.
Right. Okay. And then you have right below, in a box titled Executive Admin, what's that name?
Dr. Jones.
Okay, so that's David Jones, right?
Right, that's
Alex's
David's-
dad?
Right.
Okay. And then next on the list is Tim Fruget, right?
Underneath sales and new product advertising, yes, I see it.
Okay, right. And do you know who Patrick is?
I don't.
Okay, do you ever speak to somebody named Patrick Riley?
I don't think so.
You know who that is? Okay.
No.
And then you come down on the left side here on finance, there's Lydia, right, at the top of the finance department?
Yes.
That's Lydia Hernandez?
Yes, she's not there anymore.
Right. And below her is Melinda, and that's the Melinda who you were just talking about earlier.
Right.
Right. And you said, in response to one of Mr. Pattis's questions, there's no HR person that you know of, but that Melinda kind of does that role, right?
Kind of. I believe she's a bookkeeper, but kind of.
Okay, okay. And then going down further, if you can kind of just pull it out a little bit, Pratika, thank you. Okay. There are a series of departments that are listed out there. You have personal assistant Stephanie on the left. That's Mr. Jones's personal assistant, yes?
I'm sorry, where are we looking?
I'm sorry, it's a little bit confusing. I'm kind of in column H here, where you see personal assistant on the left-hand
Oh,
side.
okay, I see it now, yes.
That's Mr., is that Alex Jones's personal assistant?
I'm not sure.
And then over here you have household, Sarah and Samantha.
Yes,
Those are two household employees for Mr. Jones?
yes.
Are they paid out of the company?
I don't know.
Okay. And then we're looking at these these departments down here. If we just read left to right, we have procurement, inventory, right?
Yes, I see that.
Operations, yes.
Yes,
IT,
yes,
you have a programmer, correct?
yes,
You have graphics design, correct?
yes,
Writers, editors, moderators, yes?
yes, I see that.
Okay, and you see production over here?
I see that, yes.
Okay. Now, Ms. Paz, I know that you, at different times, haven't been sure which depositions you read, but did you read Kit Daniels' deposition?
Did I read Kit's deposition? I may have. I know I spoke to Kit.
Mm-hmm. Do you remember, but you don't recall whether you read his
I
deposition
don't
or not?
recall if I read his depo.
Okay. Well, Your Honor, we made a deal with the jury here. It's 3:30, so I don't want to keep anybody past where we are. I do have more redirect, but we'll just finish that up on Tuesday.
I think that's a good idea.
Thank you.
So, we are not gonna see you until Tuesday. You now have 3 days to make sure that you avoid any and all media coverage of this case. And of course, 3 days where you cannot give in to any temptation that you might have to go online, look anything up, or anywhere else. So no research, no media coverage, and no discussing anything that's transpired in this courtroom with each other or with anyone at home or any of your friends, or if you go to work on Monday, anyone at work. All right, so I know you'll honor those rules. I hope you have a wonderful weekend, and Monday we will see you Tuesday. We will plan starting right at 10, so if you could continue to be as prompt. Actually, you guys are always early, but if you could keep that up, we would all appreciate it. I'm gonna stay on the record, and we will see you again on Tuesday. And Ron, of course, will safeguard your notepads.
Lost track of time.
I'll do that again. I am glad you reminded me at 3:30. I lost track of the time, and I did promise him 3:30, and I did not. I wanted to keep my word with your jury.
I just received some criticism from my team for ending too early, so I appreciate you saying that.
Well, no, once I tell them, I want us to keep our word. So we have the issue, we haven't taken our afternoon recess yet, so I don't know how, I'll talk to Mr. Farrow and our monitor in a second, but don't we want to deal with for the 10th time, the FSS PQPR issue? Is this a good one?
This is a great time.
All right, so just give me one moment, please, Madam Monitor.
Or do you want to take a break and come back, whatever you want? I can ask them.
Can I get, can you give me an idea of how long you think the argument will take? I wanna, we didn't have our afternoon break. If it's gonna be short, I think we could probably skip it and just end for the day, but if you think it's gonna be a longer argument, then we have to take an afternoon recess.
You're right, I don't think this is long.
Attorney Pattis?
I don't know what they're gonna say. I told you earlier I'd rely on my papers, so unless something surprises me, I'll agree.
Okay, so why don't we try to see if we can do it and then adjourn for the day? Whenever
Okay,
you're ready.
So this was originally our motion to compel. The spreadsheet, excuse me. I'm back on the last motion, Your Honor.
Right, and just so that I
Yeah.
don't, I'm gonna follow the same exercise, if you could just give me the name, date, or entry numbers, and I wanna get it from both sides so that I have everything.
Okay, that is gonna take a moment, Your Honor.
Okay. I had, the original motion for order at 9:26, I think.
Okay, I have the document. That's correct, Your Honor. Sorry, I'm not standing. Motion for order at 9:26.
And then I think I have Attorney Pattis, your brief, just give me 1 second. At 9:82, filed on September 14, or no?
That
Yes?
sounds right, Judge.
Okay, and are those the only two documents that I'm looking at?
No, Your Honor, there's a reply brief at docket number 948.
Yes, I see that, 9:48, September 2nd.
Then, Your Honor, you entered an order permitting an affidavit to be filed. And I'm just looking for the docket number of that order. And that order permitted the affidavit to be filed, I believe it was Thursday of last week.
That's correct.
All right, is that everything?
No, Your Honor, then, the affidavit was filed eventually, that was filed on September 14th. And that's docket number
Yes.
982.
That's the one that I referenced, 982, right. So clearly I'm going to consider it,
Yes.
even though it's late, it's not a problem.
That's understood, Your Honor, and that is actually the reason why we need to have argument. Because, so where this started was that there was testimony from Lydia Hernandez, Free Speech Systems accountant, and from Alex Jones regarding the existence of a management agreement between PQPR and Free Speech Systems. And what this goes to, I know Your Honor has heard argument before about PQPR, but the dispute between the parties is that the defendants claim that PQPR is an actual independent entity. The plaintiffs disagree with that for a number of reasons, including the fact that the best evidence we have so far shows that PQPR is wholly controlled by the Jones family, has no employees, and revenue that is supposedly being generated by it has been paid into Free Speech Systems. So there is a hot contest about the existence of PQPR as a real independent entity. And so the request for the production of the management agreement goes to that issue. There was testimony that it existed.
And so what was produced, that memorandum of understanding that was all redacted?
So that, the Mr. Schwartz's affidavit indicates that in his understanding, that's not a memorandum of between the two companies. So he says, in other words, that's not it. And the other thing that is attached to his affidavit, and this is, so he produced two things attached to his affidavit.
Yes.
The first is a 2007 document concerning free speech systems, corporate organization. That document is responsive to discovery requests that we made in January of January of 2019. So that has never been produced to us before. This is more of the same in terms of shortcomings in production. Then turning on to what was attached at the end of the document, Mr. Schwartz's affidavit, the current CRO, says that's not, in his understanding, a memorandum of, I'm gonna get my, it's not a management agreement. That's what he says. So what is given to us is a document that should have been produced. I mean, that final attachment exhibit C.
But his affidavit says he doesn't think there's a management agreement.
Your Honor, it does say that he doesn't think there is a management agreement based on review of the files, but the overall picture is that there is testimony that there was. There's documents, more documents that were withheld. And once again, we're in a position where we were trying to take discovery on this issue, and we just don't have the full record to work with. How could we cross-examine witnesses on the existence, on their claim that this entity exists without these documents?
I understand exactly what you're saying, but wouldn't this require an evidentiary hearing? How do we know that Ms. Hernandez was not referring to the memorandum of understanding, or Mr. Jones?
Your
I mean,
Honor,
it might actually be that there is no management agreement in existence, correct?
it is possible that there's no management agreement, but the difficulty here is, look how far we are.
Sure.
We're just finding documents that were not disclosed to us previously. This just can't be happening in the middle of trial. And
Yet
so-
it is.
And yet it is. And so we've been prejudiced on the exploration of this question about whether PQPR actually exists as an independent entity. There's no question about the prejudice based on this record.
All right, so essentially, Mr. Jones and Ms. Hernandez testified to the existence of a management agreement, but Mr. Schwartz couldn't find one.
Mr. Schwartz indicates he couldn't find one.
Right.
Mr. Schwartz then gave additional documents.
That
which
should have been, I understand
produced.
that should have been produced, what wasn't produced, but, so what you have is Mr. Schwartz saying, I can't find it, but you have Mr. Jones and Ms. Hernandez testifying that there was a management agreement.
That's correct.
Attorney Pattis?
The best thing that's happened to me in the 3 years that I've been in this case, in spite of 2 firings and rehirings and the court denying my motion to withdraw, is to move into bankruptcy, because it's given me a management team that I can get answers from. This issue came up. Mr. Schwartz checked. I think I can tell you that a precondition of getting into bankruptcy court was trying to create some internal management accountability. It took months to get that done. I don't know that, I would be in a better position were there a management agreement, because that would support an independent relationship between the two things. Frankly, the plaintiffs are better off without one. That supports their argument that they're not separating these things. I think this goes to its weight rather than its admissibility. If the court wants to have an evidentiary hearing, I think for lay people, the difference between a management agreement and a memorandum of understanding might not be that significant. As to the claim that we should have produced it a long time ago, yeah, we should have. But you've heard a little bit about with the situation down there. You'll do what you're gonna do, I'll rely on my papers beyond that.
I'm just trying to figure out, Mr. Pattis, why should, because I've heard your arguments, I listened to your arguments, I read what you file, and there's a picture painted of, you know, sort of a lack of record-keeping and structure and such. And it seems almost like the defendants are asking to benefit from that. Let me just finish. What I have is Mr. Jones, who is in charge, and Ms. Hernandez saying that such a document existed, and not surprisingly, poor Mr. Schwartz comes along and can't find it.
All I can say, just is if you think getting ourselves into a default position benefited us, you see the world differently than I do. The failure to provide simple answers to simple questions on a consistent basis from one case to the next, from 1 month to the next in the same case, has been my client's undoing. You gave me the opportunity to get an affidavit, I got it, it speaks for itself. I would ask the court to not enter additional sanctions. At some point, the plaintiffs, should be required to prove their case on the merits. From the day I got involved